The part where there are not charges. And there's also the question, Martha, about the security clearance. You have the House Speaker now asking the intelligence community to yank Hillary Clinton's security clearance based on this. And that's one of the things the FBI director talked about the other day that would be a consequence, potentially, short of charges.
Committee on Oversight and Government Reform will come to order.
Indeed, he did. In fact, he said to the contrary, those individuals are often subject to security or administrative sanctions, but he said that is not what we are deciding here. That was out of the FBI's purview. Jason Chaffetz now gaveling this in, and we begin, and we're going to take you to it live. Here we go.
I tell you, I'm here because we're mystified and confused by the fact pattern that you laid out and the conclusions that you reached. It seems that there are two standards, and there's no consequence for these types of activities and dealing in a careless way with classified information. It seems to a lot of us that the average Joe, the average American, that if they had done what you laid out in your statement, that they'd be in handcuffs. And they might be on their way to jail, and they probably should. And I think there is a legitimate concern that there is a double standard. If your name isn't Clinton, or you're not part of the powerful elite, that Lady Justice will act differently. It's a concern that Lady Justice will take off that blindfold and come to a different conclusion. Hillary Clinton created this mess. It wasn't Republicans, it wasn't anybody else. She made a very conscious decision. On the very day that she started her Senate confirmation, she set up and got a domain name and set up a system to avoid and bypass the safety, security, and the protocol of the State Department. Classified information is classified for a reason. It's classified because if it were to get out into the public, there are nefarious actors, nation states, others, that want to do harm to this country. And there are people who put their lives on the line, protecting and serving our country. And when those communications are not secure, it puts their lives in jeopardy. This classified information is entrusted to very few, but there is such a duty and an obligation to protect that, to fall on your sword to protect that. And yet there doesn't seem to be any consequence. You know, I was talking to Trey Gowdy, and he made a really good point with us yesterday. Mr. Gowdy said, you know, in your statement, Mr. Director, you mentioned that there was no precedent for this. But we believe that you have set a precedent, and it's a dangerous one. The precedent is if you sloppily deal with classified information, if you're cavalier about it, and it wasn't just an innocent mistake, this went on for years, that there's going to be no consequence. We're a different nation in the United States of America. We are self-critical. Most nations would never do this. But we do it in the spirit of making ourselves better. There'll be all kinds of accusations about political this and political that. I have defended your integrity every step of the way. You are the definitive voice. I stand by that. But I am mystified, and I am confused, because you listen to your fact pattern and come to the conclusion that there is no consequence. I don't know how to explain that. We'll have constituents ask us. They'll get mad. They'll pound it. You know, they're frustrated. They've seen this happen time and time again. I don't know how to explain it. And I hope that through this hearing, we can stick to the facts and understand this, because there does seem to be two standards. There does seem to be no consequence. And I want to understand that. And I want to be able to explain it to the person that's sitting at home. And that's why we're here. And so I yield back. Now recognize the ranking member, Mr. Cummings.
Director Comey, thank you for being here today. I want to begin by commending you and the public servants at the FBI for the independent investigation you conducted. You had a thankless task. No matter what recommendation you made, you were sure to be criticized. There's no question that you were extremely thorough. In fact, some may even say you went too far in your investigation. But of course, that was your job. That is your job. Secretary Clinton has acknowledged that she made a mistake in using a personal email account. And you explained on Tuesday that she and her colleagues at the State Department were extremely careless with their emails. But after conducting this exhaustive review, you determined that no reasonable prosecutor would bring a case based on this evidence. And you and the career staff recommended against prosecution. Based on the previous cases you examined, if prosecutors had gone forward, they would have been holding the Secretary to a different standard from everyone else. Amazingly, some Republicans who were praising you just days ago for your independence, for your integrity, and your honesty instantly turned against you because your recommendation conflicted with the predetermined outcome they wanted. In their eyes, you had one job, and one job only: to prosecute Hillary Clinton. But you refused to do so. So now you are being summoned here to answer for your alleged transgressions. And in a sense, Mr. Director, you're on trial. Contrary to the claims of your critics, there is absolutely no evidence that you made your recommendation for political reasons, no evidence that you were bribed or coerced or influenced, no evidence that you came to your conclusion based upon anything but the facts and the law. I firmly believe that your decision was not based on convenience, but on conviction. Today, House Republicans are doing what they always do, using taxpayers' money to continue investigating claims that have already been debunked just to keep them in the headlines one more day. When they hear a political siren, they rush towards it over and over again, even if the evidence is not there. Exhibit A. Majority Leader Kevin McCarthy, who admitted on national television that Republicans established the Benghazi Select Committee to bring down Secretary Clinton's poll numbers. I didn't say that. McCarthy said it. The fact was confirmed by a Republican staffer on that committee who reported that he was fired in part for not going along with the hyper-focus on Secretary Clinton. I give House Republicans credit. They certainly are not shy about what they are doing. They've turned political investigations into an art form. If our concerns here today are with the proper treatment of classified information, then we should start with a review of our previous hearing on General David Petraeus, who pled guilty last year to intentionally and knowingly compromising highly classified information. The problem is, Mr. Director, we never had that hearing. This committee ignored that breach of national security because it did not match the political goals of the House Republicans. If our concerns today were with finally addressing a broken classification system in which security levels are arbitrarily changed up and down, that would have been a legitimate goal. That would have been a valuable addition to reforming and improving our government. After all, we are the Government Reform Committee. We could have held hearings here on Zika, the Zika virus, preventing gun massacres like the one in Orlando, or a host of other topics that could actually save people's lives. But that's not why we're here. That is not why our chairman called this emergency hearing 48 hours after you made your recommendation. Everyone knows what this committee is doing. Honestly, I would not be surprised, and I say this with all seriousness, I would not be surprised if tomorrow Republicans set up a new committee to spend $7 million plus on why the FBI failed to prosecute Hillary Clinton. Director Comey, let me conclude with this request. Even with all that I have said, I believe that there is a critical role for you today. I've listened carefully to the coverage on this issue, and I've heard people say recently as this morning, 3 hours ago, that they were mystified by your decision. As a matter of fact, the chairman repeated it a minute ago. And so there is a perceived gap between the things you said on Tuesday and your recommendation. There's a gap, Mr. Director. So in this moment, and this is a critical moment, I beg you to fill the gap. Because when the gap is not filled by you, it will be filled by others. Share with us, the American people, your process and your thinking. Explain how you examine the evidence, the law, and the precedent. Describe in clear terms how you and your team, career professionals, arrived at this decision. If you can do that today, if you can do that, that could go a long way towards people understanding your decision. Finally, I want to make it clear that I condemn these completely unwarranted political attacks against you. They have attacked you personally. They have attacked your integrity. They have impugned your professionalism. And they have even suggested that you were somehow bought and paid for because you made your recommendation based upon the law and the facts. I know you are used to working in a world of politics, but these attacks have been beyond the pale. So you do not deserve this. Your family does not deserve it, and the highly skilled and dedicated agents of the FBI do not deserve it. I honor your professionalism and your service to our country. And again, even if it takes till hell freezes over, I beg you to close the gap. Tell us what happened between what you found and your decision so that not only the members of this panel and this Congress will understand, but so that Americans will understand. And if you do that, then it will be all worth it today. With that, I yield back.
Mr. Chairman.
I think, hold on one second. With your indulgence, to the ranking member of which I have the greatest respect, you asked for a hearing on General Petraeus and how that was dealt with. You got it. We will have one in this Oversight Committee, and the record will reflect that in the Judiciary Committee, I repeatedly questioned Attorney General Holder. I repeatedly questioned the FBI director about the disposition of that case, probably more than any member in the House or Senate. And if you want a hearing, we'll do that.
Mr. Gentleman, you?
Yes.
Thank you.
Number two, you complained that we haven't done a hearing on Zika. The Oversight and Government Reform Committee, I believe, was the very first committee to actually do a hearing on Zika that was chaired by Mr. Micah. And I'm proud of the fact that we did a Zika hearing, and we did it first.
Gentleman yield?
Sure.
Can we have another one because the problem is still there?
Absolutely.
Big time. Thank
Absolutely.
Mr. Chairman, I just unanimous consent request that we put the date of the hearing in the record at this time that I chaired. Thank you.
Absolutely.
On Zika.
And the ranking member knows that we have held multiple hearings on the criminal justice and criminal justice reform. You asked for it, you're passionate about it, and we did do that as well. So to suggest we haven't addressed some of those issues, I think is inaccurate.
I don't think I did that, Mr. Chairman, but again, as late as yesterday with the problem in Minnesota with an African-American man being killed, I'd like to have some hearings still on the criminal justice system. Thank you.
Thank you, gentlemen. Without objection, I'm going to work with you on that, as I have every step of the way.
Thank you, Mr. Chairman. Appreciate
Without
it.
objection, the chair is authorized to declare recess at any time. We'll hold the record open for 5 legislative days for any members who would like to submit a written statement. We'll now recognize our distinguished witness for our first panel. Pleased to welcome the Honorable James Comey, the Director of the Federal Bureau of Investigations. We welcome Director Comey and thank you for being here. Pursuant to committee rules, all witnesses are to be sworn before they testify. If you'll please rise and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect that the witness answered in the affirmative. Mr. Comey, the floor is yours. You can take as long or as short as you'd like. If you have any written statement that you would like to submit afterwards, we're happy to do that as well. It will be made part of the record. The time is now yours. Director Comey, you're recognized.
Thank you, Mr. Chairman. Mr. Cummings, members of the committee, I am proud to be here today representing the people of the FBI who did this investigation as they do all their work in a competent, honest, and independent way. I believe this investigation was conducted consistent with the highest traditions of the FBI. Our folks did it in an apolitical and professional way, including our recommendation as to the appropriate resolution of this case. As I said in my statement on Tuesday, I expected there would be significant public debate about this recommendation, and I'm a big fan of transparency, so I welcome the conversation we're going to have here today. And I do think a whole lot of folks have questions about, so why did we reach the conclusion we did, and what was our thinking? And I hope very much to get an opportunity to address that and to explain it. And I hope at the end of the day people can disagree, can agree, but they will at least understand that the decision was made and the recommendation was made the way you would want it to be, by people who didn't give a hoot about politics, but who cared about what are the facts, what is the law, and how have similar people, all people, been treated in the past. Maybe I could just say a few words at the beginning that would help frame how we think about this. There are 2 things that matter in a criminal investigation of a subject. What did the person do? And when they did that thing, what were they thinking? When you look at the 100 years plus of the Justice Department's investigation and prosecution of the mishandling of classified information, those 2 questions are obviously present. What did the person do? Did they mishandle classified information? And when they did it, did they know they were doing something that was unlawful? That has been the characteristic of every charged criminal case involving the mishandling of classified information. I'm happy to go through the cases in particular. In our system of law, there's a thing called mens rea. It's important to know what you did, but when you did it, this Latin phrase mens rea means, what were you thinking? And we don't want to put people in jail unless we prove that they knew they were doing something they shouldn't do. That is the characteristic of all the prosecutions involving mishandling of classified information. There is a statute that was passed in 1917 that on its face makes it a crime, a felony, for someone to engage in gross negligence. So that would appear to say, well, maybe in that circumstance, you don't need to prove they knew they were doing something that was unlawful. Maybe it's enough to prove that they were just really, really careless, beyond a reasonable doubt. At the time Congress passed that statute in 1917, there was a lot of concern in the House and the Senate about whether that was going to violate the American tradition of requiring that before you're going to lock somebody up, you prove they knew they were doing something wrong. And so there was a lot of concern about it. The statute was passed. As best I can tell, the Department of Justice has used it once in the 99 years since, reflecting that same concern. I know from 30 years with the Department of Justice, they have grave concerns about whether it's appropriate to prosecute somebody for gross negligence, which is why they've done it once that I know of in a case involving espionage. And so when I look at the facts we gathered here, as I said, I see evidence of great carelessness, but I do not see evidence that is sufficient to establish that Secretary Clinton or those with whom she was corresponding both talked about classified information on email and knew when they did it, they were doing something that was against the law. Right? So given that assessment of the facts, my understanding of the law, my conclusion was and remains, no reasonable prosecutor would bring this case. No reasonable prosecutor would bring the second case in 100 years focused on gross negligence. And so I know that's been a source of some confusion for folks. That's just the way it is. I know the Department of Justice. I know no reasonable prosecutor would bring this case. I know a lot of my former friends are out there saying they would. I wonder where they were the last 40 years, because I'd like to see the cases they brought on gross negligence. Nobody would, nobody did. So my judgment was the appropriate resolution of this case was not with a criminal prosecution. As I said, folks can disagree about that, but I hope they know that view, not just my view, but of my team, was honestly held, fairly investigated, and communicated with unusual transparency because we know folks care about it. So I look forward to this conversation. I look forward to answering as many questions as I possibly can. I'll stay as long as you need me to stay because I believe transparency matters tremendously, and I thank you for the opportunity.
Thank you, Director. I'm going to recognize myself here. Physically, where were Hillary Clinton's servers?
The operational server was in the basement of her home in New York. The reason I'm answering it that way is sometimes after they were decommissioned, they were moved to other facilities, storage facilities, but the live device was always in the basement.
Was that an authorized or unauthorized location?
It was an unauthorized location for the transmitting of classified information.
Is it reasonable or unreasonable to expect Hillary Clinton would receive and send classified information?
As Secretary of State, reasonable that the Secretary of State would encounter classified information in the course of the Secretary's work.
Via email?
Sure, depending upon the nature of the system. To communicate classified information would have to be a classified rated email system.
But you did find more than 100 emails that were classified that had gone through that server, correct?
Right, through an unclassified server, correct.
Yes. So Hillary Clinton did come to possess documents and materials containing classified information via email on these unsecured servers, correct?
That is correct.
Did Hillary Clinton lie?
To the FBI, we have no basis to conclude she lied to the FBI.
Did she lie to the public?
That's a question I'm not qualified to answer. I can speak about what she said to the FBI.
Did Hillary Clinton lie under oath?
Not to the FBI, not in a case we're working.
Did you review the documents where Congressman Jim Jordan asked her specifically, and she said, quote, "There was nothing marked classified on my emails, either sent or received," end quote?
I don't remember reviewing that particular testimony. I'm aware of that being said, though.
Did the FBI investigate her statements under oath on this topic?
Not to my knowledge. I don't think there's been a referral from Congress.
Do you need a referral from Congress to investigate her statements under oath?
Sure do.
You'll have one. You'll have one in the next few hours. Did Hillary Clinton break the law?
In connection with her use of the email server, my judgment is that she did not.
Did you just not able to prosecute it, or did Hillary Clinton break the law?
Well, I don't want to give an overly lawyerly answer. The question I always look at is there evidence that would establish beyond a reasonable doubt that somebody engaged in conduct that violated a criminal statute? And my judgment here is there is not.
The FBI does background checks. If Hillary Clinton applied for the job at the FBI, would the FBI give Hillary Clinton a security clearance?
I don't want to answer a hypothetical. The FBI has a robust process in which we adjudicate the suitability of people for employment in the Bureau.
Given the fact pattern you laid out less than 48 hours ago, would a person who had dealt with classified information like that, would that person be granted a security clearance at the FBI?
It would be a very important consideration in a suitability determination.
You're kind of making my point, Director. The point being, because I injected the word Hillary Clinton, you gave me a different answer. But if I came up to you and said that this person was extremely careless with classified information, the exposure to hostile actors, and used, despite warnings, created unnecessary burdens and exposure, If they said that they had one device and you found out that they had multiple devices, if there had been email chains with somebody like Jake Sullivan asking for classification changes, you're telling me that the FBI would grant a security clearance to that person?
I hope I'm giving a consistent answer. I'm not saying what the answer would be. I'm saying that would be an important consideration in a suitability determination for anybody.
And it's just, personally, I just think that sounds like a bit of a political answer, because I can't imagine that the FBI would grant a security clearance to somebody with that fact pattern. Do you agree or disagree with that?
I just say what I said before. Again, it's very hard to answer in the hypothetical. I'll repeat it. It would be a very important consideration in a suitability determination.
Did Hillary Clinton do anything wrong?
And what do you mean by wrong?
I think it's self-evident.
Well, I'm a lawyer, I'm an investigator, and I hope a normal human being.
Do you really believe there should be no consequence for Hillary Clinton and how she dealt with this?
Well, I didn't say, I hope folks remember what I said on Tuesday. I didn't say there's no consequence for someone who violates the rules regarding the handling of classified information. There are often very severe consequences in the FBI involving their employment, involving their pay, involving their clearances. That's what I said on Tuesday, and I hope folks walk away understanding that just because someone's not prosecuted for mishandling classified information, that doesn't mean if you work in the FBI, there aren't consequences for it.
So if Hillary Clinton, or if anybody, had worked at the FBI under this fact pattern, what would you do to that person?
There would be a security review and an adjudication of their suitability, and a range of discipline could be imposed from termination to reprimand, and in between suspensions, loss of clearance. So you could be walked out, or you could, depending on the nature of the facts, you could be reprimanded. But there is a robust process to handle that.
I've gone past my time. I yield back. Now recognize the ranking member, Mr. Cummings.
Thank you very much, Director Comey, and I want to thank you very much for being here today, especially on such short notice. You and your staff should be commended for the thorough and dedicated review you conducted. Unfortunately, some of my colleagues are now attacking you personally because your final recommendation conflicted with their preconceived political outcome in this case. Some have tried to argue that this case is far worse than the case of General David Petraeus, who was convicted in 2015 of knowingly and intentionally compromising highly classified information. In fact, one very vocal politician we all know said this, and I quote, "If she isn't indicted, the only reason is because the Democrats are protecting her. She is being protected 100%. Because you look at General Petraeus, you look at all the other people that did a fraction of what she did, but she has much worse judgment than he had, and she's getting away with it, and it's unfair to him," end of quote. Director Comey, you were the director of the FBI when General Petraeus pled guilty, is that right?
Yes.
If I understand that case correctly, General Petraeus kept highly classified information in 8 personal notebooks at his private residence. Is that correct?
That is correct.
According to the filings in that case, his notebook included the identities of covert officers. They also included war strategy, intelligence capabilities, diplomatic discussions, quotes and deliberative discussions from high-level National Security Council meetings, and discussions with the President. General Petraeus shared his information with his lover and then biographer. He was caught on audio tape telling her, and I quote, "I mean, they are highly classified, some of them. They don't have it on it, but I mean, there's code word stuff in there," end of quote. Director Comey, what did General Petraeus mean when he said he intentionally shared, quote, code word information with her? What does that mean?
The Petraeus case, to my mind, illustrates perfectly the kind of cases the Department of Justice is willing to prosecute. Even there, they prosecuted him for a misdemeanor. In that case, you had vast quantities of highly classified information, including special sensitive compartmented information. That's the reference to code words. Vast quantity of it, not only shared with someone without authority to have it, but we found it in a search warrant hidden under the insulation in his attic, And then he lied to us about it during the investigation. So you have obstruction of justice, you have intentional misconduct, and a vast quantity of information. He admitted he knew that was the wrong thing to do. That is a perfect illustration of the kind of cases that get prosecuted. In my mind, it illustrates, importantly, the distinction to this case.
And General Petraeus did not admit to these facts when the FBI investigators first interviewed him, did he?
No, he lied about it.
But he did admit to these facts in a plea agreement, is that correct?
Yes.
Here's what the department filing said about General Petraeus, and I quote, "The acts taken by defendant David Howell Petraeus were in all respects knowing and deliberate and were not committed by mistake, accident, or other innocent reason," end of quote. Is that an accurate summary in your view, Director Comey?
Yes, it actually leaves out an important part of the case, which is the obstruction of justice.
Was he charged with obstruction of justice?
No.
And why not?
A decision made by the leadership of the Department of Justice not to insist upon a plea to that felony.
So the question is, do you agree with the claim that General Petraeus, and I quote, got in trouble for far less, end of quote?
No.
Do you agree with that statement?
No, it's the reverse.
And what do you mean by that?
His conduct, to me, illustrates the categories of behavior that mark the prosecutions that are actually brought. Clearly intentional conduct, knew what he was doing was a violation of the law. Huge amounts of information that even if you couldn't prove he knew it, it raises the inference that he did it, right? An effort to obstruct justice. That combination of things makes it worthy of a prosecution. A misdemeanor prosecution, but a prosecution nonetheless.
Sitting here today, do you stand by the FBI's recommendation to prosecute General Petraeus?
Oh, yeah.
Do you stand by the FBI's recommendation not to prosecute Hillary Clinton?
Oh, yes.
Director Comey, how many times have you testified before Congress about the General Petraeus case? Do you know?
I don't think I've ever testified. I don't think I've testified about it at all. I don't think so.
With that, I'll yield back.
I have to check the record, but I believe I asked you a question about it at the time, but maybe not.
You could have. That's why I was squinching my face. It could have been at a Judiciary Committee hearing I was asked about it.
Yeah. We'll now recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Good morning, Director Comey. Secretary Clinton said she never sent or received any classified information over her private email. Was that true?
Our investigation found that there was classified information sent.
So it was not true?
Right. That's what I said.
Okay. Well, I'm looking for a little shorter answer, so you and I are not here quite as long. Secretary Clinton said there was nothing marked classified on her emails, either sent or received. Was that true?
That's not true. There were a small number of portion markings on, I think, 3 of the documents.
Secretary Clinton said, I did not email any classified material to anyone on my email. There is no classified material. Was that true?
There was classified material emailed.
Secretary Clinton said she used just one device. Was that true?
She used multiple devices during the 4 years of her term as Secretary of State.
Secretary Clinton said all work-related emails were returned to the State Department. Was that true?
No, we found work-related emails, thousands, that were not returned.
Secretary Clinton said neither she nor anyone else deleted work-related emails from her personal account. Was that true?
That's a harder one to answer. We found traces of work-related emails on devices or in Slack space, whether they were deleted or whether when a server was changed out, something happened to them. There's no doubt that there were work-related emails that were removed electronically from the email system.
Secretary Clinton said her lawyers read every one of the emails and were overly inclusive. Did her lawyers read the email content individually?
No.
Well, in the interest of time, and because I have a plane to catch tomorrow afternoon, I'm not going to go through any more of the false statements, but I am going to ask you to put on your old hat. False exculpatory statements, they are used for what?
Well, either for a substantive prosecution or for evidence of intent in a criminal prosecution.
Exactly. Intent and consciousness of guilt, right? Is that right?
Right.
Consciousness of guilt and intent. In your old job, you would prove intent, as you just referenced, by showing the jury evidence of a complex scheme that was designed for the very purpose of concealing the public record. And you would be arguing, in addition to concealment, the destruction that you and I just talked about, or certainly the failure to preserve. You would argue all of that under the heading of content. You would also be arguing the pervasiveness of the scheme, when it started, when it ended, and the number of emails, whether they were originally classified or up-classified. You would argue all of that under the heading of intent. You would also probably, under common scheme or plan, argue the burn bags of daily calendar entries or the missing daily calendar entries as a common scheme or plan to conceal. 2 days ago, Director, you said a reasonable person in her position should have known a private email was no place to send and receive classified information. You're right, an average person does know not to do that. This is no average person. This is a former First Lady, a former United States Senator, and a former Secretary of State that the President now contends is the most competent, qualified person to be president since Jefferson. He didn't say that in 08, but he says it now. She affirmatively rejected efforts to give her a state.gov account. She kept these private emails for almost 2 years and only turned them over to Congress because we found out she had a private email account. So you have a rogue email system set up before she took the oath of office, thousands of what we now know to be classified emails, some of which were classified at the time. One of her more frequent email comrades was in fact hacked, and you don't know whether or not she was. And this scheme took place over a long period of time and resulted in the destruction of public records, and yet you say there is insufficient evidence of intent. You say she was extremely careless, but not intentionally so. You and I both know intent is really difficult to prove. Very rarely do defendants announce, on this date, I intend to break this criminal code section. Just to put everyone on notice, I am going to break the law on this date. It never happens that way. You have to do it with circumstantial evidence. Or if you're Congress and you realize how difficult it is to prove specific intent, you will formulate a statute that allows for gross negligence. My time is out, but this is really important. You mentioned there's no precedent for criminal prosecution. My fear is there still isn't. There's nothing to keep a future Secretary of State or President from this exact same email scheme or their staff. And my real fear is this. It's what the chairman touched upon. This double-track justice system that is rightly or wrongly perceived in this country. That if you are a private in the Army and you email yourself classified information, you will be kicked out. But if you are Hillary Clinton and you seek a promotion to Commander-in-Chief, you will not be. So what I hope you can do today is help the average person, the reasonable person you made reference to, the reasonable person understand why she appears to be treated differently than the rest of us would be. With that, I would yield back.
We'll now recognize the gentlewoman from New York, Ms. Maloney.
Director, thank you for your years of public service. You have distinguished yourself as the Assistant U.S. Attorney for both the Southern District of New York and the Eastern District of Virginia. That's why you were appointed by President Bush to be the Deputy Attorney General at the Department of Justice, and why President Obama appointed you as the Director of the FBI in 2013. Despite your impeccable reputation for independence and integrity, Republicans have turned on you with a vengeance immediately after you announced your recommendation not to pursue criminal charges against Secretary Clinton. Let me give you some examples. Representative Turner said, and I quote, "The investigation by the FBI is steeped in political bias," end quote. Was your investigation steeped in political bias, yes or no?
No, it was steeped in no kind of bias.
Thank you. The Speaker of the House, Paul Ryan, was even more critical. He accused you of not applying the law equally. He said your recommendation shows, and I quote, "The Clintons are living above the law. They're being held to a different set of standards. That is clearly what this looks like," end quote. How do you respond to his accusations that you held the Clintons to a different set of standards than anyone else? Did you hold them to a different standard or the same standard?
It's just not accurate. We try very hard to apply the same standard whether you're rich or poor, white or black, old or young, famous or not known at all. I just hope folks will take the time to understand the other cases, because there's a lot of confusion out there about what the facts were of the other cases that I understand lead good people, reasonable people to have questions.
Senator Cruz also criticized you. He said that there are, and I quote, "serious concerns about the integrity of Director Comey's decision." He stated that you, quote, "you had rewritten a clearly worded federal criminal statute." Did you rewrite the law in any way or rewrite any statute?
No.
Now, I truly hesitate to mention the next one. But Donald Trump took these conspiracy theories to a totally new level. He said, and I quote, "It was no accident that charges were recommended against Hillary the exact same day as President Obama campaigned with her for the first time." So did you plan the timing of your announcement to help Secretary Clinton's campaign event on Tuesday?
No. Timing was entirely my own. Nobody knew I was going to do it, including the press. I'm very proud of the way the FBI, nobody leaked that. We didn't coordinate it, didn't tell. Just not a consideration.
Thank you. Mr. Trump also claimed that Secretary Clinton bribed the Attorney General with an extension of her job. And I guess this somehow affected your decision. I know it's a ridiculous question, but I have to ask it. Did you make your decision because of some kind of bribe to the Attorney General?
No.
I tell you, are you surprised, as I am, by the intensity of the attacks from the GOP on you after having made a decision, a thoughtful decision, an independent decision with the professional staff of the FBI?
I'm not surprised by the intense interest and debate. I predicted it. I think it's important that we talk about these things. They inevitably become focused on individual people. That's okay. We'll just continue to have the conversation.
I believe that what we're seeing today is that if the GOP does not like the results of an investigation or how it turns out, and we saw they originally were lauding you, the minute you made your announcement, they're now attacking you, the same people. And now I predict they'll be calling for more hearings, more investigations, all at the expense of the taxpayer. And they do this instead of working on what the American people really care about. They want Congress to focus on jobs, the environment, homeland security, the security of our nation, affordable child care, affordable college educations, and an economy that works and helps all people. I thank you for performing your job with distinction and the long history of your whole profession of integrity and independence. And thank you very much. My time has expired.
Thank the gentlewoman. We'll now recognize the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Thank you, Mr. Chairman. Director, thank you for being with us. On Tuesday, you said any reasonable person in Secretary Clinton's position should have known that an unclassified system was no place for these conversations. You said on Tuesday some of her emails bore classified markings, and you also said on Tuesday there were potential violations of the appropriate statutes. Now, I know a bunch of prosecutors back home would look at that fact pattern, look at that evidence. You even referenced it in your opening statement. Some of your friends in the prosecution business have been on TV saying they'd have looked at that same evidence and they would have taken it to a grand jury. But on Tuesday you said, and today in your opening statement you said, no reasonable prosecutor would bring such a case. And then in your statement Tuesday you cite factors that helped you make that decision and make that statement. And one of the factors you said was consider the context of a person's actions. Now, typically when I hear context in the course of a criminal investigation, it's from the defense side, not the prosecution side. It's at the end of the case after there's been a trial and a guilty verdict, and it's during the sentencing phase, mitigating circumstances. That's the context we typically think about, but you said it on the front end. You said consider the context of the person's actions, and so I'm curious, what does consider the context mean? Because a lot of Americans are thinking just what the chairman talked about in his opening statement, that there are two standards, one for we the people and one for the politically connected. A lot of folks I get the privilege of representing back in Ohio think that when you said consider the context, they think that's what Mr. Gowdy just talked about, the fact that she's former First Lady, former Secretary of State, former Senator, major party's nominee for the highest office in the land, and oh, by the way, her husband just met with the individual you work with at an airport in Arizona 5 days ago. So you said none of that influenced your decision, but tell us what consider the context means.
Yeah, thank you, Mr. Jordan. What I was trying to capture is the fact that the exercise of prosecutorial discretion is always a judgment call. It is in every single case. And among the things you consider are, what was this person's background? What was the circumstances of the offense? Were they drunk? Were they inflamed by passion? Was it somebody who had a sufficient level of education and training and experience that we can infer certain things from that? To consider the entire circumstances of the person's offense conduct and background. I did not mean to consider political context or things like that.
The entire circumstances, and Mr. Gowdy just talked about this scheme. Remember what she did, right? She sets up this unique server arrangement. She alone controls it. On that server, on that email system are her personal emails, her work-related emails, Clinton Foundation information, and now we know classified information. This gets discovered. We find out this arrangement exists. Then what happens? Her lawyers, her legal team decides which ones we get and which ones they get to keep. They made the sort on the front end. And then we find out the ones that they kept and didn't give to us, didn't give to the American people, didn't give to Congress, the ones they kept, they destroyed them. And you don't have to take my word, I'll take what you said on Tuesday. They deleted all emails that they did not return to the State Department, and the lawyers cleaned their devices in such a way as to preclude complete forensic recovery. Now that sounds like a fancy way of saying they hid the evidence, right? And you just told Mr. Gowdy thousands of emails fell into those categories. Now, that seems to me to provide some context to what took place here. Did Secretary Clinton's legal team, let me ask it this way. Did Secretary Clinton know her legal team deleted those emails that they kept from us?
I don't believe so.
Did Secretary Clinton approve those emails being deleted?
I don't think there was any specific instruction or conversation between the Secretary and her lawyers about that.
Did you ask that question?
Yes.
Did Secretary Clinton know that her lawyers cleaned devices in such a way as to preclude complete forensic recovery?
I don't believe that she did.
Did you ask that question?
Yes.
Do you see how someone could view the context of what she did? Set up a private system. She alone controlled it. She kept everything on it. We now know from Ms. Abedin's deposition that they did it for that very reason, so no one could see what was there, based on the deposition Ms. Abedin gave. And then when they got caught, they deleted what they had, and they scrubbed their devices. Is that part of the context in evaluating this decision?
Sure, sure. And understand what inferences can be drawn from that collection of facts, of course.
All right. Mr. Chairman, I yield back.
Thank the gentleman. Now recognize the gentlewoman from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, I appreciate your conduct of this investigation in a nonpartisan way, in keeping with the sterling reputation which has led presidents of both parties to appoint you to highly placed law enforcement positions in our federal government. I want to say for the record that this hearing, where you call the prosecutor and Mr. Comey stands in the place of the prosecutor, because the Attorney General has accepted entirely the FBI's recommendations, where you call the prosecutor to give account for the decision to prosecute or not. A particular individual raises serious questions of separation of powers, and particularly when you're questioning the prosecutor's decision with respect to the decision to prosecute or not a particular individual, it raises serious bill of attainder constitutional questions. These hearings are so often accusatory that they yield no guidance as to how to conduct business in the future. And that's the way it looks. It looks as though that is how this hearing is going. Now, of course, now everyone understands in the abstract why it is important for security reasons to use official government mail or email rather than private email if security matters are involved. And that's a very broad, wide proposition. Now, there are no rules, so far as I know, requiring members of Congress to use their as to how they use their official email accounts, whether involving security or not. The chairman of this committee lists his personal account, for example, on his business card. No one says that's wrong. I don't know if it's wrong or right, because there's no guidance. Federal agency employees, members of Congress often have secure information, or at least sensitive information that shouldn't be made public. Some of our members are on the Intelligence Committee or the Defense Committee or even this committee and may have such matters. Some of these matters may concern national security issues. I don't know if something as sensitive as the itinerary, if you're going on a Codell, as to the route you are taking and where you will be, all that could be on people's personal emails. Of course, this is legislative branch, and I spoke of separation of powers. I'm not indicating that there should be a government-wide sense that is ordained from on high, but there ought to be rules that everybody understands about, especially after the Clinton episode, about the use of personal email. So I'd like your insight for guidance as far as other federal employees are concerned, or even members of Congress and their staff, because I think we could learn from this episode. So strictly from a security standpoint, do you believe that federal employees, staff, even members of Congress should attempt guidance on the issue of the use of personal emails versus some official form of communication? What should we learn from the process the Secretary has gone through? I'm sure there will be questions about how there was even confusion, for example, in the State Department. But what should we learn when it comes to our own use of email or the use of federal employees on this question?
May I answer, Mr. Chairman? The most important thing to learn is that an unclassified email system is no case for an email conversation about classified matters. And by that I mean either sending a document as an attachment over unclassified email that is classified, or having a conversation about something that is a classified subject on an unclassified email system. That's the focus of the concern. That's the focus of this investigation. That it was also a personal email adds to the concern about the case because of the security vulnerabilities associated with a personal system. But the root of the problem is people using unclassified systems to conduct business. That is classified. And so all of us should have access to, if we have access to classified information, classified communication systems. Right? The FBI has 3 levels: unclassified system, a secret system, and a top secret system. You can email on all 3. But you need to make sure you don't email on the unclassed system, even if that's a government classified system, about matters that are classified. That's the important lesson to learn. Everybody ought to be aware of it. Everybody ought to be trained on it. We spend a lot of time training on it in the FBI to make sure folks are sensitive to the need to move a classified discussion, even if it doesn't involve sending a document, to the appropriate forum.
Members of Congress included.
Of course.
Thank you, Mr. Chairman.
We'll now recognize the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Director, and the reason why that's so important is because if top secret information is compromised, that could damage our national security, correct?
Yes, by definition.
And American lives are at stake in some instances, correct?
Yes.
You mentioned a lot of people are upset that there are no consequences for Secretary Clinton, but in your statement you did point out that administrative and security consequences would be appropriate if someone demonstrated extreme carelessness for classified information. So those consequences, that would include potentially termination of federal employment?
Correct.
It could include revocation of security clearance?
Yes.
And it could include ineligibility for future employment in national security positions, correct?
It could.
Now, would you, as the FBI director, allow someone in the employ of your agency to work in a national security capacity if that person had demonstrated extreme carelessness in handling top secret info?
The best answer to that is we would look very closely at that in a suitability determination. It's hard to answer in the abstract, yes in all cases, no in all cases, but it would be a very important suitability scrub.
So there would be instances where someone could be extremely careless but still maintain confidence? I mean, we have a lot of people who are very competent in this country who would love to work for your agency, but yet it would be potentially you would allow somebody to be extremely careless and continue on?
That's the trouble with answering the hypothetical. I could imagine if it was a long time ago and it was a small amount of conduct or something, that's why it's hard to say other than it would be a very important part of
Let's just put it this way. Would being extremely careless in handling top secret information expose an employee of the FBI to potential termination?
Yes.
Why shouldn't U.S. officials use mobile devices when traveling to foreign countries, especially if they're discussing classified or sensitive information?
Because the mobile device will transmit its signal across networks that are likely controlled or at least accessed by that hostile power.
And that's the guidance that the FBI gives all officials when they're traveling overseas. That's still good guidance, correct?
That's good guidance.
How did top secret information end up on the private server? Because your statement addressed Secretary Clinton. You did not address any of her aides in your statement. Attorney General Lynch exonerated everybody. That information just didn't get there on its own. So how did it get there? Were you able to determine that?
Yes, by people talking about a top secret subject in an email communication.
So
it's not about forwarding a top secret document. It's about having a conversation about a matter that is top secret.
And those were things that were originated by Secretary Clinton's aides and then sent to her, which was obviously being her server, but it was also included Secretary Clinton originating those emails, correct?
That's correct. In most circumstances, it initiated with aides starting a conversation. In the one involving top secret information, Secretary Clinton, though, also not only received but also sent emails that talked about the same subject.
And of that top secret information that you found, would somebody who was sophisticated in those matters, should it have been obvious to them that that was very sensitive information?
Yes.
So I guess my issue about knowledge of what you're doing is, in order for Secretary Clinton to have access to top secret SCI information, didn't she have to sign a form with the State Department acknowledging her duties and responsibilities under the law to safeguard this information?
Yes. Anybody who gets access to SCI, sensitive compartmented information, would sign what's called a read-in form that lays that out. I'm sure members of Congress have seen the same thing.
And it stresses in that document, and other training people would get, that there are certain requirements to handling certain levels of information. For example, a top secret document, that can't even be on your secret system at the FBI, correct?
Correct.
So you have to follow certain guidelines. And I guess my question is she's a very sophisticated person. She did execute that document, correct?
Yes.
And her aides who were getting the classified information, they executed similar documents to get a security clearance, correct?
I believe so.
And she knowingly, clearly set up her own private server in order to, well, actually, let me ask you that. Was the reason she set up her own private server in your judgment because she wanted to shield communications from Congress and from the public?
I can't say that. Our best information is she set it up as a matter of convenience. It was an already existing system that her husband had, and she decided to have a domain on that system.
So the question is very sophisticated. This is information that clearly anybody who had knowledge of security information would know that it would be classified. But I'm having a little bit trouble to see how would you not then know that that was something that was inappropriate to do?
Well, I just want to take one of your assumptions about sophistication. I don't think that our investigation established that she was actually particularly sophisticated with respect to classified information and the levels and the treatment. And so far as we can tell,
isn't she an original classification authority, though?
Yes, sir. Yes, sir.
Good grief. Well, I appreciate you coming, and I yield back the balance of my time.
I thank the gentleman. I ask unanimous consent to enter into the record two documents that Mr. DeSantis referred to. One is the sensitive compartmented information non-disclosure agreement. The other one is the classified information non-disclosure agreement, both signed by Hillary Rodham Clinton. Without objection, so ordered. Now recognize the gentleman from Missouri, Mr. Clay, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director Comey, for being here today and for the professionals whom you lead at the FBI. 2 years ago, after my urgent request to then former Attorney General Eric Holder for an expedited Justice Department investigation into the tragic death of Michael Brown in Ferguson, Missouri, I witnessed firsthand the diligence, professionalism, and absolute integrity of your investigators. And I have no doubt that was the case in this matter as well. I did not think it was possible for the majority to exceed their unprecedented, arrogant abuse of official channels and federal funds that we have witnessed over the past 2 years, as they have engaged in a partisan political witch hunt at taxpayer expense against Secretary Clinton. But I was wrong. This proceeding is just a sequel to that very bad act, and the taxpayers will get the bill. It's a new low, and it violates both House rules and the rules of this committee. So with apologies to you and the FBI for this blatantly partisan proceeding, let me return to the facts of this case as you have clearly outlined them. First question. Did Secretary Clinton or any member of her staff intentionally violate federal law?
We did not develop clear evidence of that.
Did Secretary Clinton or any member of her staff attempt to obstruct your investigation?
We did not develop evidence of that.
In your opinion, do the mistakes Secretary Clinton has already apologized for and expressed regret for rise to a level that would be worthy of federal prosecution?
As I said Tuesday, our judgment, not just mine, but the team's judgment at the FBI, is that the Justice Department would not bring such a case. No Justice Department under any, whether Republican or Democrat administration.
Thank you for that response. I know the FBI pays particular attention to groups by training agents and local law enforcement officers and participating in local hate crime. Some of these organizations seem relatively harmless, but others appear to be very dangerous and growing. Some even promote genocide in their postings and rhetoric online. In your experience, how dangerous are these groups, and have they incited violence in the past?
I think too hard to answer, Congressman, in the abstract. There are some groups that are dangerous. There are some groups that are exercising important protected speech under the First Amendment.
Okay, let me ask about a more direct question. A gentleman named Andrew Anglin is the editor of a website called The Daily Stormer that is dedicated to the supremacy of the white race as well as attacking Jews, Muslims, and others. The website features numerous posts with the hashtag white genocide to protest what they contend is an effort to eliminate the white race. Are you familiar with this movement?
I'm not.
Okay. Well, this hashtag has been promoted all over social media by a growing number of white supremacists. For example, one Nazi sympathizer tweeted repeatedly using the handle @WhiteGenocideTM. Are you concerned that some groups are increasing their followers in this way, particularly if some of those followers could become violent?
I don't know the particular enough to comment, Congressman. We are always concerned when people go beyond protected speech, which we do not investigate, to moving towards acts of violence. And so our duty is to figure out when have people walked outside the First Amendment protection and are looking to kill folks or hurt folks. But I don't know enough to comment on the particular.
I see. Well, one of my biggest concerns is that certain public figures are actually promoting these dangerous groups even further. And as you may know, one of our most vocal candidates for president retweeted @WhiteGenocideTM. 3 weeks later, he did it again. 2 days after that, he retweeted a different user whose image also included the term white genocide, and that's not even all of them. Director Comey, don't these actions make it easier for these racist groups to recruit even more supporters?
I don't think I'm in a position to answer that in an intelligent way sitting here.
Well, I appreciate you trying, and thank you, Mr. Director, for your exceptional and principled service to our country. I yield back.
Thank you. We'll now recognize the gentlewoman from Wyoming, Ms. Lummis, for 5 minutes.
Welcome, Director, and thank you so much for being here. My phone has been ringing off the hook in my Washington office, in my Wyoming office, from constituents who don't understand how this conclusion was reached. So I appreciate your being here to help walk us through it. And here's the issue that the people that are calling me from Wyoming are having. They have access to this statute. It's Title 18, U.S. Code 1924, and I'm going to read you this statute. It says, whoever being an officer, employee, contractor, or consultant to the United States, and by virtue of his office, employment, position, or contract, becomes possessed of documents or materials containing classified information of the United States, knowingly removes such documents or materials without authority and with the intent to retain such documents or materials at an unauthorized location, shall be fined under this title or imprisoned for not more than 1 year or both. Armed with that information, they're wondering how Hillary Clinton, who is also an attorney, and attorneys are frequently held to a higher standard of knowledge of the law, how this could not have come to her attention. She was the Secretary of State. Of course the Secretary of State is going to become possessed of classified materials. Of course she was attorney. She practiced with a prominent Arkansas law firm, the Rose Law Firm. She knew from her White House days with her husband, the president, the classified materials can be very dangerous if they get into the wrong hands. She had to have known about this statute because she had to have been briefed when she took over the job as the Secretary of State. So how, given that body of knowledge and experience, could this have happened in a way that could have potentially provided access by hackers to confidential information?
No, it's a good question, a reasonable question. The protection we have as Americans is that the government in general and in that statute in particular, has to prove before they can prosecute any of us that we did this thing that's forbidden by the law, and that when we did it, we knew we were doing something that was unlawful. We don't have to know the code number, but that we knew we were doing something that was unlawful. That's the protection we have, and it's one I've worked for very hard. When I was in the private sector, I did a lot of work with the Chamber of Commerce to stop the criminalization of negligence in the United States.
You know, though, may I interrupt and suggest that this statute says knowingly remove such documents or materials without authority and with the intent to retain such documents or materials at an unauthorized location. The intent here in the statute is to retain the documents at an unauthorized location. It's not intent to pass them on to a terrorist or to someone out in internet land. It's just the intent to retain the documents or materials at an unauthorized location.
Yeah, it's more than that, though. You'd have to show that and prove criminal intent, both by law, that's the way the judge would instruct a jury, and practice of the Department of Justice. They have reserved that statute, even though it's just a misdemeanor, for people who clearly knew they were breaking the law, and that's the challenge. So should have known, must have known, had to know, does not get you there. You must prove beyond a reasonable doubt that they knew they were engaged in something that was unlawful.
Okay,
that's the challenge.
May I turn to her attorneys? Did all of Secretary Clinton's attorneys have the requisite clearances at the time they received all of her emails, especially those that were classified at the time they were sent?
No.
They destroyed, as has been noted, 30,000 emails of Secretary Clinton's. Do you have 100% confidence that none of the 30,000 emails destroyed by Secretary Clinton's attorneys was marked as classified?
I don't have 100% confidence. I'm reasonably confident some of them were classified. There were only 3 in the entire batch we found that bore any markings that indicated they were classified. So that's less likely, but surely it's a reasonable assumption that some of the ones they deleted contain classified information.
Thank you, Director. Thank you, Mr. Chairman. I yield back.
Now recognize the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Director Comey, for appearing here to help the committee with this work. Director Comey, Secretary Clinton is certainly not the only Secretary of State to use a personal email account with information later identified as being classified. I just want to show you, this is a book that was written by former Secretary of State Colin Powell, and in his book he says, to complement the official State Department computer in my office, I installed a laptop computer and on a private line. My personal email account on the laptop allowed me to direct access to anyone online. So I started shooting emails to my principal assistants, to individual ambassadors, and increasingly to my foreign minister colleagues who, like me, were trying to bring their ministries into the 186,000 miles per second world. Were you aware of this, that Secretary Colin Powell actually had a private server as well?
Not a private server. I think he used a commercial email account for State Department business.
Private line, unprotected.
Correct. Not a State Department email system.
Right, right. He went rogue, so to speak. Right?
I don't know where I'd say that.
Yeah, all right. Okay, I'm not going to put words in your mouth. But do you think this was careless for him to do that, to start, get his own, he got his own system. He installed a laptop computer on a private line. My personal email account was on a laptop and allowed me direct access to anyone online. That's his own statement. I'm just trying to compare secretaries of state, because Secretary Powell's never been here. Matter of fact, when we asked him for his emails, unlike the 55,000 that we received from Secretary Clinton, he said, "I don't have any to turn over." This is a quote. This was on ABC's This Week. He explained, "I don't have any to turn over. I didn't keep a cache of them. I did not print them off. I do not have thousands of pages somewhere in my personal files." But he was Secretary of State, and he operated on a private system. Were you aware of that?
Not at the time, 15 years ago, but I am now.
Yeah. Okay. So recently, well, back in October 2015, the State Department sent Secretary Powell a letter requesting that he contact his email provider, AOL, to determine whether any of his emails are still on the unclassified systems. Are you aware of that ongoing investigation?
I don't know of an investigation.
Well, that request for information from Secretary Powell, former Secretary.
Yes, yes, I am.
You're aware of that. Are you surprised that he has never responded?
I don't know enough to comment. I don't know exactly what conversation he had with the State Department.
All right. I'm trying to look at the, where we have a lot of comparisons in other cases, and it seems like all the cases where prosecutions have gone forward, the subject of the investigation has demonstrated a clear intent to deliver classified information to a person or persons who were unauthorized to receive that. So if you look at the, PFC Bradley Manning, now Chelsea Manning, that was a court-martial, but he demonstrated a clear intent to publish that information, which was classified. Julian Assange, the WikiLeaks editor, I guess, and publisher, again, a wide and deliberate attempt to publish classified information. General Petraeus, which we talked about earlier today, shared information with his biographer. Jeffrey Sterling, sending stuff to the New York Times. Former CIA officer Kiriakou, who was interested in writing a book, so he hung on to his information. And even former director of the CIA, John Deutsch, who retained classified information on a couple of servers, one in Belmont, Massachusetts, and one in Bethesda, Maryland. And that was after he became a private citizen. So in all those cases, there's a clear intent. As you said before, you look at what people did and what they were thinking when they did that. And I would just ask you, is there a clear distinction between what those people did and what Secretary Clinton did in her case?
In my view, yes. The Deutsch case illustrates it perfectly. And he took huge amount of documents, almost all at the TSSCI level, had them in hard copy at his house, had them on an unclassed system connected to the internet, attempted to destroy some of them when he got caught, admitted, I knew I wasn't supposed to be doing this. So you have clear intent, huge amounts of documents, obstruction of justice. Those are the kind of cases that get prosecuted. That's what I said when I meant it when I said it. In my experience, which is 3 decades, no reasonable prosecutor would bring this case. I know that frustrates people, but that's the way the law is, and that's the way the practice is of the Department of Justice.
All right. Thank you for your testimony and for your service. I yield back.
Thank the gentleman. We'll now go to the gentleman from North Carolina, Mr. Meadows, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, thank you. There's been much said today about criticizing you and your service. And I want to go on record that even though many of my constituents would love for me to criticize your service because of the conclusion you reach, never have I, nor will I, criticize your service, and we appreciate your service to this country and the integrity. So I'm going to focus on the things that you said, not the conclusion that you drew. And Congressman Trey Gowdy and I talked a little bit about this, but on February 4th, 2016, Secretary Clinton, during a presidential debate, said, I never sent or received any classified material. They are retroactively classifying it, close quote. And so in your statement on July 5th, you said that there were indeed 110 emails, 52 email chains, which there was classified information on it at the time it was sent or received. So those two statements, both of them cannot be true. Is that correct? Your statement and her statement.
Yeah, it's not accurate to say that she did not send or receive classified.
So she did not tell the truth during that presidential debate that she never sent or received classified information and that it was retroactively classified.
Yeah, I don't think that's a question I should be answering. What was in her head during...
Either your statement's not true or hers is not true. Both of them cannot be true. So is your statement true?
That I can speak to.
Okay, your statement is true, so the American people will have to judge with her statement not being true. So let me go on to another one. On October 22nd, she said there was nothing marked classified on emails either sent or received. And in your statement, you said a very small number of emails contain classified information, bore markings indicating the presence of classified information at the time. So she makes a statement that says there was no markings. You make a statement that there was, so her statement was not true.
Well, that one actually I have a little bit of insight into her statement because we asked her about that. There were 3 documents that bore portion markings where you're obligated when something is classified to put a marking on that paragraph.
Right.
And there were 3 that bore C in parens, which means that's confidential classified information.
So a reasonable person who has been a senator, a secretary of state, a first lady, wouldn't a reasonable person know that that was a classified marking as a secretary of state?
Yeah.
A reasonable person. That's all I'm asking.
Yeah, before this investigation, I probably would have said, yes, I'm not so sure. I don't find it incredible.
Director Comey, come on. I mean, I've only been here a few years, and I understand the importance of those markings. So you're suggesting that a long length of time that she had no idea what a classified marking would be? That's your sworn testimony today?
No, not that she would have no idea what a classified marking would be, but it's an interesting question as to whether this question about sophistication came up earlier, whether she was actually sophisticated enough to understand what a C in parens means.
So you're saying this former Secretary of State is not sophisticated enough to understand a classified marking?
No, that's not what I'm saying.
That's a huge statement.
I know what I'm saying. You asked me, did I assume that someone would know? Probably before this investigation I would have. I'm not so sure of that answer any longer. I think it's possible that she didn't understand what a C meant when she saw it in the body of an email like that. It's possible.
After years in the Senate and Secretary of State, I mean, that's hard for me and the American people to believe, Director Comey, and I'm not questioning your analysis of it, but wouldn't a reasonable person think that someone who has the highest job of handling classified information understand that?
I think that's a conclusion a reasonable person would draw. It may not be accurate, but that's
so
what
in that, let me go a little bit further, because that last quote actually came on October 22nd, 2015, under sworn testimony before the Benghazi Committee. So if she gave sworn testimony that a reasonable person would suggest was not truthful, isn't it a logical assumption that she may have misled Congress, and we need to look at that further?
Well, the reasonable person test is not what you look at for perjury or false statements. But like I said, I can understand why people would ask that question.
All right, so let me, in the last little portion of this, in your 3.5-hour interview on Saturday, did she contradict some of these public statements in private? Because you said she didn't lie to the FBI, but it's apparent that she lied to the American people. So did she change her statements in that sworn testimony with you last Saturday?
I haven't gone through that to parse that.
Can you do that and get back to this committee? Because it's important, I think, to the American people and to transparency.
Oh, I'm sure. And as the chairman and I have talked about, I'm sure the committee is going to want to see the documents in our investigation and whatnot, and we'll work to give you whatever we can possibly give you under our law. But I haven't done that analysis at this point.
Will you get that back to us?
Gentleman's time has expired. And we'll now recognize the gentleman from Tennessee, Mr. Cooper, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director Comey. I hate to see one of America's most distinguished public servants pilloried before this committee. We're all highly partisan here. We're good backseat drivers. We're all today, apparently, armchair prosecutors. And you stated the truth when you said that you didn't know of anyone who would bring a case like this. And some of the prosecutors have had decades to do that. I hope that this committee's effort is not intended to intimidate you or the FBI or law enforcement in general or government employees. And I'm thankful at this moment that you have such a lifetime record of speaking truth to power, because that's very important. It's also very important that apparently you're a lifelong Republican. You're just here to do your job, to state the facts. I think the key issue here is whether, in fact, there's a double standard, whether some Americans are being treated differently than others. And I think I can rely on my Republican colleagues to make sure that Hillary Clinton's treated no better than anybody else. There should be some attention given to make sure that she's not treated any worse than anybody else. I think we all know that we wouldn't be having this hearing, especially on an emergency basis, unless she were running for president. My colleague from Massachusetts has just pointed out that previous secretaries of state are not being called on the carpet, whether that be Condoleezza Rice or Colin Powell or others. But I think the grossest double standard here today is the fact that all the members of this committee, every member of Congress, is not subject to the same law that Secretary Clinton was subject to. And as lawmakers, that means that we have exempted ourselves from the standard of other federal employees. My colleague from D.C., Ms. Norton, referred to this. Why did we exempt ourselves from the same rules? Apparently, our chairman lists his private email account on his business card. We all have access to classified information. So I would like to challenge my Republican colleagues here today. Let's work together and introduce legislation to make the same laws apply to us as apply to the executive branch and to Secretary Clinton. I would be happy to join in such legislation to make sure that we're not being hypocritical on this panel, that we're holding ourselves to the same standards as Secretary Clinton, and not trying to accuse her of things that we may be guilty of ourselves. I bet my colleagues would be the first to complain if, for example, emails were retroactively classified. That's a situation that most people in public service would object to pretty strongly. How did you know at the time if you had no idea? So I think it's very important, if we want, as Congress, to have the trust of the American people, to not be hypocritical, to uphold the same standards that we want to see upheld by others. And I'm just thankful at this moment in our history that we have someone like you who's in charge of the FBI. Because too many things are highly politicized. The last thing we should do is criminalize our political system. I didn't see any of my Republican colleagues complain when former Governor Bob McDonnell was exonerated by an 8-0 vote of the Supreme Court for having done certain things that I think most Americans would find highly objectionable. But our court, on a bipartisan, unanimous basis, exonerated him just a week or two ago. So I think this is a moment for committee members to reflect, to take a deep breath, to calm down, and realize exactly what you said, that no reasonable prosecutor would have brought this case. And thank you for stating that so clearly and publicly. I yield back the balance. I yield to the ranking member.
Mr. Director, let me ask you this. First of all, I associate myself with everything the gentleman just said. You were talking about some markings a little bit earlier, is that right? Can you describe what those markings are like? Markings on documents. I think you said there were 3 documents with certain markings on them that indicated classified. Go ahead.
There were 3 emails that down in the body of the email, in the 3 different emails, there were paragraphs that at the beginning of the paragraph had a parenthesis, a capital C, and then a parenthesis. And that is a portion marking to indicate that
that
paragraph is classified at the confidential level, which is the lowest level of classification.
And so out of the 30,000 documents, you found these 3 markings? Is that what you're saying?
3 emails bore C markings down in the body. None of the emails had headers, which is at the top of a document that says it's classified. 3 had within the body the portion marking for C.
Thank you.
Thank the gentleman. I now recognize the gentleman from Tennessee, Mr. Duncan, for 5 minutes.
Thank you, Mr. Chairman. Mr. Meadows mentioned one instance in which Secretary Clinton said that she did not mail any classified material to anyone. Actually, she said that several other times. But it is accurate, Director Comey, that you found at least 110 instances of when she had emailed classified material.
110 that she either received or sent.
Right. And it also is accurate that, quote, Clinton's lawyers cleaned their devices in such a way as to preclude complete forensic recovery.
Correct.
And also, when she said, when Secretary Clinton said that nothing she sent was marked classified, and you said in your press conference, but even if information is not marked classified in an email, particularly our participants who know or should know that the subject matter is classified are still obligated to protect it. Do you feel that Secretary Clinton knew or should have known that she was obligated to protect classified information?
Yes.
With her legal background and her long experience in government. Also, she said at one point that she has directed all emails, work-related emails, to be forwarded to the State Department. Is it also accurate that you discovered thousands of other emails that were work-related other than the 30,000 that she submitted?
Correct.
Before I came to Congress, I spent several years as a criminal court judge. I presided over several hundred felony criminal cases. And I can assure you that I saw many cases where the evidence of criminal intent was flimsier than the evidence in this case. But do you realize, or do you realize that great numbers of people across this country felt that you presented such a strong, such an incriminating case against Secretary Clinton in your press conference that they were very surprised or even shocked when you reached the conclusion to let her off? Do you doubt that great numbers feel that way?
No, I think so, and I understand the questions. And I wanted to be as transparent as possible. We went at this very hard to see if we could make a case, and I wanted the American people to see what I honestly believed about the whole thing.
Well, do you understand, as the chairman said earlier, that great numbers of people feel now that there's one standard of justice for the Clintons and another for regular people?
Yeah, I've heard that a lot. It's not true, but I've heard it a lot.
Well, even the ranking member who was here, who of course, as we understand, had to defend Secretary Clinton as strongly as possible, he almost begged you to explain the gap between the incriminating case that you presented and the conclusion that was reached. Did that surprise you, that he felt so strongly that there was this big gap?
No, not at all. No, it's a complicated matter. It involves understanding how the Department of Justice works across decades, how prosecutorial discretion is exercised. I get that folks see disconnection, especially when they see a statute that says gross negligence. Well, the director just said she was extremely careless, so how is that not prosecutable? So it takes an understanding of what's gone on over the last 99 years. What's the precedent? How do we treat these cases? I totally get people's questions, and I think they're in good faith.
Do you, we talk about gross negligence here, and you said that Secretary Clinton was extremely careless with this classified material and how dangerous it could be, how threatening to even to people's lives that it could be to disclose classified material. Do you agree that there is a very thin line between gross negligence and extreme carelessness? And would you explain to me what you consider to be that that difference?
Sure, Judge. Congressman, as a former judge, you know there isn't actually a great definition in the law of gross negligence. Some courts interpret it as close to willful, which means you know you're doing something wrong. Others drop it lower. My term, extremely careless, is I'm trying to be kind of an ordinary person. That's a common sense way of describing it. Sure looks real careless to me. The question of whether that amounts to gross negligence, frankly, is really not at the center of this, because when I look at the history of the prosecutions and see it's been one case brought on a gross negligence theory, I know from 30 years there's no way anybody at the Department of Justice is bringing a case against John Doe or Hillary Clinton for the second time in 100 years based on those facts.
You ended your statement to Congressman Cooper a while ago saying once again that no reasonable prosecutor could have brought this case, yet you also mentioned earlier today that you had seen several of your friends and other prosecutors who've said publicly, many across this country, that they would have been glad to prosecute this case.
I smile because they're friends. and I haven't talked to them. I want to say, guys, so where were you over the last 40 years? Where were these cases? They just have not been brought. For reasons that I said earlier, it's a good thing that the Department of Justice worries about prosecuting people for being careless. I don't like it. As a citizen, I want people to show they knew they were breaking the law, and then we'll put you in jail.
Of course, you know many people have been prosecuted for gross negligence by the federal government, by the FBI.
Gentleman's time has expired.
Thank you.
We'll now recognize the gentleman from Virginia, Mr. Conley, for 5 minutes.
Thank you, and welcome, Director Comey. And although our politics are different, I gather you're a Republican. Is that correct?
I have been registered Republican for most of my adult life.
All right.
I'm not registered any longer.
We don't register by party in Virginia, but many have suspected my politics as being Democratic. And I thank you for your integrity. As my colleague said, and I said in my opening statement, your career has been characterized as speaking truth to power. And you're doing it again today. Just to set the context, Director Comey, not that you're unaware of this, today's hearing is political theater. There's not even the pretense of trying to get at the truth. This is a desperate attempt under an extraordinary set of circumstances, an emergency hearing. I don't know what the emergency is other than one side is about to nominate somebody who is a pathological narcissist who was talking about banning Muslims and Mexicans crossing the border who are all rapists and women who are pigs, and terrified at the prospect of the consequences of that in the election. So let's grab onto whatever we can to discredit or try to discredit the other nominee, putative nominee. And you took away their only hope. And so the theater today is actually trying to discredit you. Subtly, in some cases. My friend from South Carolina uses big words like exculpatory and kind of goes through what a prosecutor would do. The insinuation being, you didn't do your job. My friend from Wyoming is apparently flooded with citizens in her home state who are reading the statute that governs classification. A lot of time on the hands back there, I guess, but yeah, this is all designed to discredit your finding. Now, the FBI interviewed Secretary Clinton, is that correct?
Yes.
Did she lie to the FBI in that interview?
I have no basis for concluding that she was untruthful with us.
And is it a crime to lie to the FBI?
Yes, it is.
David Petraeus did lie to the FBI.
Yes.
And he was prosecuted for that. Oh, well, could have been.
Could have been, was not for that.
Right. That's always a judgment call.
Correct.
Was she evasive?
I don't think the agents assessed she was evasive.
How many emails are we talking about, total, universe, that were examined by your team?
Tens of thousands.
Tens of thousands. And how many are in a questionable category that maybe coulda, shoulda been looked at more carefully because there could be some element of classification? Apparently my friend from North Carolina assumes we're all intimately familiar with the fact that if a C appears, it means a classification, though there seems to be some dispute about that because the State Department, as I understand it, has actually said some of those were improperly marked and shouldn't have had the C. Aware of that?
Yes.
Yes. So could it be that in her 100 overseas trips to 100 countries, as Secretary of State trying to restore U.S. credibility that had been destroyed in the previous 8 years overseas, and tens of thousands of email communications, not including phone calls and classified conversation and SCIFs and the like, that maybe the small percentage of emails she didn't pay as much attention to them as maybe, in retrospect, one would hope she would have. Is that a fair conclusion? Could that be a fair conclusion?
I don't usually deal in maybes. It's possible.
Well, you do deal in distinguishing between willful and inadvertent.
Sure.
And in this case, you concluded it has to be in the latter category. It wasn't willful.
We concluded there was not adequate evidence of willful conduct.
Right. So there's no obfuscation here, unlike the Petraeus case. And there's no evasion, there's no lying, there's no willful intent to compromise classified material, despite the insinuations of my friends on the other side of the aisle. And the only hope left in this political theater is to discredit you and your team in the hopes that, therefore, you won't have credibility and we can revisit this monstrous crime of using a private server, that server being the server of the former President of the United States that maybe Mrs. Clinton thought would be more secure than the leaky system at the State Department. I yield back.
Now I recognize the gentleman from Texas, Mr. Hurd, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I'm offended. I'm offended by my friends on the other side of the political aisle saying this is political theater. This is not political theater. For me, this is serious. I spent 9.5 years as an undercover officer in the CIA. I was the guy in the back alleys collecting intelligence, passing it to lawmakers. I've seen my friends killed. I've seen assets put themselves in harm's way. And this is about protecting information, the most sensitive information the American government has. And I wish my colleagues would take this a little bit more seriously. Mr. Comey, Director Comey, excuse me. SAP, Special Access Program, you alluded to earlier, that includes SCI information. Does SCI information include HUMINT and SIGINT?
Yes.
HUMINT and SIGINT, human intelligence information collected from people that are putting themselves in harm's way to give us information to drive foreign policy. Signals intelligence, some of the most sensitive things to understand what Al-Qaeda is doing, what ISIS is doing. So, the former Secretary of State had an unauthorized server, and those are your words, in her basement, correct?
Correct.
Who was protecting that information? Who was protecting that server?
Well, not much. There was a number of different people who were assigned as administrators of the server.
And at least 7 emails chains, or 8, that was classified as TS-SCI.
Correct.
So the former Secretary of State, one of the President's most important advisors on foreign policy and national security, had a server in her basement that had information that was collected from our most sensitive assets, and it was not protected by anyone, and that's not a crime? That's outrageous. People are concerned. What does it take for someone to misuse classified information and get in trouble for it?
Well, it takes mishandling it and criminal intent.
And so an unauthorized server in the basement is not mishandling?
Well, no, there is evidence of mishandling here. This whole investigation at the end focused on, is there sufficient evidence of intent?
Was this unanimous opinion within the FBI on your decision?
Well, the whole FBI wasn't involved, but the team of agents, investigators, analysts, technologists, yes.
Did you take into any consideration the impact that this precedence can set on our ability to collect intelligence overseas?
Yes. My primary concern is the impact on what other employees might think in the federal government.
And you don't think this sends a message to other employees that if the former Secretary of State can have an unauthorized server in their basement that transmits top secret information, that's not a problem?
Oh, I worry very much about that. That's why I talked about that in my statement, because an FBI employee might face severe discipline, and I want them to understand that those consequences are still going to be there.
Director Comey, do you have a server in your basement?
I do not.
Does anybody in the FBI have a server in their basement or in their house?
I don't know. Not.
Do you think it's likely?
I think it's unlikely.
I would think so too.
I
would think so too, because I've been proud to serve alongside the men and women that you represent. So there was no dissenting opinion when you made this decision. It's your job to be involved in counterintelligence as well, right?
Yes.
So that means protecting our secrets from foreign adversaries collecting them. Is that correct?
Correct.
Did this activity you investigated make America's secrets vulnerable to hostile elements?
Yes.
Do you think that pattern of behavior would continue?
I'm sorry, I missed the
Do you think that pattern of behavior would continue?
Would continue
by our former Secretary of State?
I'm not following. You mean if this had not come to light, you mean?
Right now, based on what we see, do you think there's going to be other elements within the federal government that think it's okay to have an unauthorized server in their basement?
Well, they better not. That's one of the reasons I'm talking about.
So, but what is the ramifications of them doing that? How is there going to be any consequences levered if it's not being levered here? Because indeed, you're setting a precedent.
Yeah, the precedent, I want people to understand, again, I only am responsible for the FBI, that there will be discipline from termination to reprimand and everything in between for people who mishandle classified information.
Director Comey, I'm not a lawyer, and so I may misstate this. Is there such a thing as the case of first impression? And why was this not possibly one of those?
There is such a thing, which just means the first time you do something. The reason this isn't one of those is that's just not fair. That would be treating somebody differently because of their celebrity status or because of some other factor. Doesn't matter. We have to treat people. It's the bedrock of our system of justice. We treat people fairly. We treat them the same based on their conduct.
And that person mishandling the most sensitive information that this government can collect is not fair? It's not fair to punish someone who did that?
Not on these facts. It would be fair, that person worked for me, it'd be fair to have a robust disciplinary proceeding. It's not fair to prosecute that person on these facts.
I thank
Mr. Chairman, I yield back the time I do not have.
Thank the gentleman. We'll now recognize the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Mr. Chairman. And I'd like to open by acknowledging my colleague from North Carolina, Mr. Meadows. Here he comes back in the room. For acknowledging your integrity, Director Comey. I think bipartisan sentiments like that are few and far between around here, and I appreciate Congressman Meadows' remark. You are a man of integrity, Director Comey. It's troubling to me that remark from Congressman Meadows is not unanimous at this point. It used to be. Just weeks ago, our chairman, Representative Chaffetz, stated on national TV that Republicans, quote, believe in James Comey, unquote. He said this, and I quote, "I do think that in all of the government, he is a man of integrity and honesty. His finger's on the pulse of this. Nothing happens without him, and I think he is going to be the definitive person to make a determination or a recommendation." But just hours after your actual recommendation came out, Chairman Chaffetz went on TV and accused you of making a, quote, political calculation. And then our Speaker of the House weeks ago, referring to you, Director Comey, said, "I do believe that his integrity is unequaled." So your integrity it was unanimous about your integrity before you came to your conclusion, but after, not so much. That's troubling. And I want to give you a chance, Director Comey. How do you respond to that? How important to you is maintaining your integrity before the nation?
I think the only two things I have in life that matter are the love of my family and friends and my integrity. So I care deeply about both.
All right. Now, Director Comey, you discussed your team a little bit, and they deserve a lot of credit for all of the hard work and effort that went into this investigation. And I think you just said that they were unanimous, that everyone who looked at this agreed that no reasonable prosecutor would bring a case. Am I correct in that?
Yes.
How many people were on this team?
It changed at various times, but somewhere between 15 and 20, and then we used a lot of other FBI folks to help from time to time.
And how many hours were spent on this investigation?
We haven't counted yet. I said to them, they put 3 years of work into 12 calendar months.
And how many pages of documents did the FBI review in this investigation?
Thousands and thousands and thousands.
And the agents doing the document review, were they qualified or were they unqualified?
They were an all-star team. They're a great group of folks.
How about Secretary Clinton? Did she agree to be interviewed?
Yes.
come in voluntarily without the need of a subpoena?
Yes.
Was she interviewed?
Yes.
Was she interviewed by experienced, critical, veteran agents and law enforcement officers, or by some kind of credulous, gullible newbies doing their on-the-job training, Director?
She was interviewed by the kind of folks the American people would want doing the interview, real pros.
All right, you were asked about markings on a few documents. I have the manual here, marking classified national security information, and I don't think you were given a full chance to talk about those 3 documents with the little C's on them. Were they properly documented? Were they properly marked according to the manual?
No.
According to the manual, and I ask unanimous consent to enter this into the record, Mr. Chairman.
Without objection, so ordered.
According to the manual, if you're going to classify something, there has to be a header on the document, right?
Correct.
Was there a header on the 3 documents that we've discussed today that had the little C in the text someplace?
No, there were 3 emails. The C was in the body, in the text, but there was no header on the email or in the text.
So if Secretary Clinton really were an expert at what's classified and what's not classified, and we're following the manual, the absence of a header would tell her immediately that those 3 documents were not classified. Am I correct in that?
That would be a reasonable inference.
All right. I thank you for your testimony, Director. I yield back.
I thank the gentleman. We'll now recognize the gentleman from Colorado, Mr. Buck, for 5 minutes.
Good morning, Director Comey.
Morning, sir.
Thank you for being here. I also respect your commitment to law and justice and your career. And first question I want to ask you, is this hearing unfair? Has it been unfair to you?
No.
Thank you. One purpose of security procedures for classified information is to prevent hostile nations from obtaining classified information. Is that fair?
Yes.
And did hostile nations obtain classified information from Secretary Clinton's servers?
I don't know. It's possible, but we don't have direct evidence of that. We couldn't find direct evidence.
I want to, without making this a law school class, I want to try to get into intent. There are various levels of intent in the criminal law, everything from knowingly and willfully doing something all the way down to strict liability. Would you agree with me on that?
Yes.
And in Title 18, most of the criminal laws in Title 18 have the words knowingly and willfully in them, and that is the standard typically that United States attorneys prosecute under.
Most do. Unlawfully, knowingly, and willfully is our standard formulation for charging a case.
And there are also a variety of others between the knowingly and willfully standard and the strict liability standard. And many, like environmental crimes, have a much lower standard because of the toxic materials that are at risk of harming individuals. Is that fair?
That's correct.
Okay. Let's talk about this particular statute, 18 U.S.C. 1924. I take it we could all agree, or you and I can agree on a couple of the elements. Secretary Clinton was an employee of the United States.
Correct.
And as the result of that employment, she received classified information.
Correct.
And there's no doubt about those 2 elements. Mm-hmm. Now, I don't know whether the next element is 1 element or 2, but it talks about knowingly remove such materials without authority and with the intent to retain such material at an unauthorized location. So I'm going to treat those as 2 separate parts of the intent element. First of all, do you see the word willfully anywhere in this statute?
I don't.
Okay. And that would indicate to you that there is a lower threshold for intent?
No, it wouldn't.
Why?
Because we often, as I understand the Justice Department's practice and judicial practice, will impute to any criminal statute at that level with a knowingly also a requirement that you know that you're involved in criminal activity of some sort, a general mens rea requirement.
So, and you would apply that same standard to environmental crimes?
No, if it specifically says it's a negligence-based crime, I don't think a judge would impute that.
But Congress specifically omitted the word willfully from this statute, and yet you are implying the word willfully in the statute. Is that fair?
That's fair.
Okay.
Yeah,
So what the statute does say is knowingly remove such materials without authority. Is it fair that she knew that she didn't have authority to have this server in her basement?
Yes, that's true.
And she knew that she was receiving materials, classified information, in the emails that she received on her BlackBerry and other devices.
I can't answer. I'm hesitating as a prosecutor because it's always to what level of proof. I do not believe there's evidence beyond a reasonable doubt that she knew she was receiving classified information in violation of the requirements.
But that's not my question.
There's evidence of that.
That's my question. My question, in fairness, is did she know that she was receiving information on the servers at her location?
Oh, so I'm sorry. Yeah, of course, yes. She knew she was using her email system.
And as Secretary of State, she also knew that she would be receiving classified information.
Yes, in general.
Okay. And did she then have the intent to retain such material at an unauthorized location? She retained the material that she received as Secretary of State at her server in her basement, and that was unauthorized.
You're asking me, did she have and I'm going to ask you the burden of proof question in a second, but did she have the intent to retain classified information on the server or just to retain any information on the server?
Well, we've already established that she knew as Secretary of State that she was going to receive classified information in her emails. And so did she retain such information that she received as Secretary of State on her servers in her basement?
She did, in fact. There is, in my view, not evidence beyond certainly probable cause. There's not evidence beyond a reasonable doubt that she knew she was receiving classified information or that she intended to retain it on her server. There's evidence of that. But when I said there's not clear evidence of intent, that's what I meant. I could not, even if the Department of Justice would bring that case, I could not prove beyond a reasonable doubt those two elements.
Okay. Thank you very much.
Thank the gentleman. Now I'll go to the gentlewoman from Illinois, Ms. Duckworth, for 5 minutes.
Thank you, Mr. Chairman. When I first entered Congress 3 years ago, like many freshman members, unlike many freshman members, I actually sought out this committee. I wanted to be on this committee because I wanted to tackle the challenges of good government, like working to eliminate improper payments or prevent wasteful programs duplication. Before I joined Congress, I had the privilege of serving in the Army for 23 years, and and as I tackled those challenges and in the challenges of helping reduce veterans' homelessness, I witnessed firsthand the real-world importance of improving and streamlining government operations, how even the best policies in the world will not work without proper implementation. And so when it comes to implementing true and lasting reforms that will make sure the electronic records and other records and the history of our great nation are preserved for future generations, I've done my best to approach this goal seriously. I'm focused on making sure that our nation sustains a long-term commitment to modernizing our federal record-keeping system, from improving the laws governing what needs to be collected, to ensuring our civil servants across government have the necessary tools to achieve what should be nonpartisan and a shared goal. With respect to examining the tough lessons learned from numerous record-keeping incidents that our committee has dealt with, which transcend any one agency or any single administration, my mission is clear. Make sure that we here in Congress move beyond partisan politics and engage in the serious, hard work of ensuring that the laws written in an era of pen and paper are overhauled to meet the digital challenges of the 21st century. Director Comey, the Office of Management and Budget and the National Archives and Records Administration released a memorandum known as the Managing Government Records Directive in 2012. And this directive states, and I quote, "By December 31st, 2016, federal agencies will manage both permanent and temporary email records in an accessible electronic format. Federal agencies must manage all email records in an electronic format. Email records must be retained in an appropriate electronic system that supports records management and litigation requirements, which may include preservation in place models, including the capability to identify, retrieve, and retain the records as long as they are needed." As a director of a bureau who deals with sensitive information on a daily basis, do you believe that this directive is necessary and attainable for agencies across the board within that 4-year time frame from August 2012 to December 2016?
I don't know enough to say both. I can say it's certainly necessary. I don't know whether it's achievable.
Okay. Are you familiar with the capstone approach? That's the federal It's an approach that says that federal agencies should save all emails for select senior level employees, and that the emails of other employees would be archived for a temporary period set by the agency, so that senior employees' emails are kept forever, and those by other lower level employees are actually archived for a shorter period.
I'm aware generally. I know what applies to me and when I was Deputy Attorney General in the Bush administration.
Agreed. Yes, in fact, I understand that the FBI is currently actively using this approach, according to the agency's Senior Agency Official for Records, Office for Records Management FY15 annual report. My understanding is the capstone approach is aimed at streamlining the record-keeping process for emails and reducing the volume of records that an agency has to maintain. Nearly all agencies will be required to comprehensively modernize their approach to managing federal records in the near future. As the head of a component agency, Director Comey, within the Department of Justice, which appears to be a leader in adopting the innovative capstone approach across the agency, would you agree that with respect to instituting foundational reforms that will strengthen records preservation, the capstone approach used by DOJ should be accelerated and rolled out across the federal government?
I think we're doing it in a pretty good way. I don't know. I'm not an expert enough to say whether everybody should do it the way we do it, honestly.
Are you satisfied with the way that you're doing it?
I am, but I don't want to sound overconfident because I'm sure there's a way we can do it better, but I think we're doing it in a pretty good way.
Do you have any one person within the FBI that continually reviews your records keeping, and also do they report directly to you, as well as is there a periodic review of how you're implementing this process?
Yes. We have an entire division devoted to records management. That assistant director reports up to the deputy director, who reports to me. It's an enormous operation, as you might imagine, requiring constant training. And so that's what I mean when I say I think we're doing it in a pretty good way. And we have record marking tools. We prompt with dialogue boxes requiring employees to make a decision. What's the nature of this record you're creating now, and where should it be stored? So I think we're doing it in a pretty good way. That's why I say that.
Have you seen that in any of the other agencies that you have interacted with, or have you had an occasion to look at what some of the other agencies are doing with their sensitive and classified information? Are they following the same technique as you're doing in the FBI?
I don't know enough to say, I personally.
Okay. I am out of time, but thank you.
Okay.
Thank the gentlewoman. We'll now recognize the gentleman from Michigan, Mr. Walberg, for 5 minutes.
I thank the chairman, and thank you, Director Comey, for being here. Mr. Chairman, thank you for holding this hearing, and Director Comey for making it very clear that you believe we've done this respectfully with good intention. And I wish some of my colleagues that had instructed us on our intent were here. They have a great ability to understand intent better than, I guess, the director of the FBI. But it is an intent that's important here, that we understand we are Oversight and Government Reform Committee. And if indeed the tools aren't there to make sure that our country is secure and that officials at the highest levels in our land don't have the understanding on what it takes to keep our country secure, that we do the necessary government reform to put laws in place that will be effective and will meet the needs of distinguished agencies and important agencies like the FBI. So thank you, Mr. Chairman, for doing this hearing. It's our responsibility to do oversight and reform as necessary. In going back, Director Comey, to paraphrase the Espionage Act, the people in the 7th District of Michigan understand it from this perspective in common sense, what it says, that whoever being entrusted with information related to national defense through gross negligence permits the information to be removed from its proper place in violation of their trust shall be fined or imprisoned under the statute. There doesn't seem to be a double standard there. It doesn't express intent. You've explained your understanding of why intent is needed, and we may agree or disagree on that, but the general public looking at that statute says it's pretty clear. The question I would ask, Director Comey, what's your definition of extremely careless, if you could go through that?
I intended it as a common sense term. It's one of those kind of you know it when you see it sort of things. Somebody who is should know better. Someone who is demonstrating a lack of care that strikes me as there's ordinary accidents, and then there's just real sloppiness. So I think of that as kind of real sloppiness.
So you stated that you had found 110 emails on Secretary Clinton's server that were classified at the time they were sent or received, yet Secretary Clinton has insisted for over a year publicly that she never sent or received any classified emails. The question I have from that, would it be difficult for any cabinet-level official, and specifically any cabinet official, let alone one who is a former White House resident or U.S. Senator, to determine if information is classified?
Would it be difficult?
Would it be difficult?
That's hard to answer in the abstract. It would depend upon the context in which they're hearing it or seeing it. Obviously, if it's marked, which is why we require markings, it's easy. It's just too hard to answer because there's so many other situations you might encounter it.
But with the training that we receive, and certainly a Secretary of State would receive, or someone who lives in the White House, that goes a little above and beyond just the common sense individual out there trying to determine, knowing that classified information will be brought and to remove to an unauthorized site ought to cause a bit of pause there, shouldn't it?
Yeah, and if you're a government official, you should be attentive to it because you know that the matters you deal with could involve sensitive information, so sure.
So Secretary Clinton's revised statement that she never knowingly sent or received any classified information is probably also untrue.
Yeah, I don't want to comment on people's public statements. We did not find evidence sufficient to establish that she knew she was sending classified information beyond a reasonable doubt to meet that the intent standard. But like I said, I understand why people are confused by the whole discussion. I get that. But you know what would be a double standard? If she were prosecuted for gross negligence.
But your statement on Tuesday said there is evidence to support a conclusion that any reasonable person in Secretary Clinton's position should have known that an unclassified system was no place for that conversation.
I stand by that.
And that's very clear.
That's the definition of carelessness, of negligence.
Which happened
Oh, yeah.
as a result of our Secretary of State's, former Secretary of State's decisions.
Yes.
Is it your statement then before this committee that Secretary Clinton should have known not to send classified material, and yet she did?
Well, certainly she should have known not to send classified information. And as I said, that's the definition of negligent. I think she was extremely careless. I think she was negligent. That I could establish. What we can't establish is that she acted with the necessary criminal intent.
Do you believe that that since the Department of Justice hasn't used the statute Congress passed, it's invalid?
No, I think they're worried that it's invalid, that it will be challenged on constitutional grounds, which is why they've used it extraordinarily sparingly in the decades.
Thank you. I yield back.
Thank the gentleman. We'll now go to, we'll now recognize Mr. Liu of California for 5 minutes.
Thank you, Mr. Chair. As I read some of my Republican colleagues' press statements, and as I sit here today, I am reminded of that quote from Macbeth, full of sound and fury, signifying nothing. I've heard some sound and fury today from members of the committee, and the reason they largely signify nothing is because of two fundamental truths that are self-evident. The first of which, none of the members of this committee can be objective on this issue. I can't be objective. I've endorsed Hillary Clinton for president, as have the Democratic members of this committee. My Republican colleagues can't be objective. They oppose Hillary Clinton for president, which is why we have you. You are a nonpartisan career public servant that has served our nation with distinction and honor. And not only can you be objective, it is your job to be objective, to apply the law fairly and equally, regardless of politics. I think it'd be important for the American people to get a fuller appreciation of your public service. So let me ask you, before you were FBI director, how many years did you serve as a federal prosecutor?
I think 15.
For a period of time, you were at Columbia Law School as a scholar, and you specialized in national security law. Is that correct?
Sometimes I fantasize I still am.
All right. Thank you. When you served in the Republican administration of President George W. Bush, you were then the second highest ranking member of the Department of Justice. Is that right?
Yes, President Bush appointed me to be U.S. Attorney in Manhattan and then the number 2 in the Department of Justice.
When you were confirmed for the FBI director position, the vote was 93-1. Is that correct?
That's correct.
With that strong bipartisan support, it's not surprising that Senator Grassley, Republican, said during your confirmation, and I quote, Director Comey has a reputation for applying the law fairly and equally regardless of politics. In this case, did you apply the law fairly and equally regardless of politics?
Yes.
Did you get any political interference from the White House?
None.
Did you get any political interference from the Hillary Clinton campaign?
None.
One of the reasons you're appointed to a fixed term of 10 years, a very long term, is to help insulate you from politics. Isn't that right?
That's correct.
The second fundamental truth today about this hearing is that none of the members of this committee have any idea what we're talking about, because we have not reviewed the evidence personally in this case. When I served on active duty in the U.S. Air Force in the 1990s, one of my duties was a prosecutor. One of the first things I learned as a prosecutor is it is unprofessional and wrong to make allegations based on evidence that one has not reviewed. So let me ask you, has any member of this committee, to the best of your knowledge, reviewed the 30,000 emails at issue in this case?
I don't know, not to my knowledge.
Has any member of this committee sat through the multiple witness interviews that the FBI conducted in this case?
No, that I know, no.
Has any member of this committee received any special information about the files that you kept or other FBI agents kept on this case?
Not to my knowledge.
Now let's do a little bit of math here. 1% of 30,000 emails would be 300 emails, is that right?
I think that's right.
Right. 30 emails would be 1/10 of 1%, and 3 emails would be 1/100th of 1% of 30,000, right?
I think that's right.
Okay. So of those 3 emails, 1/100th of 1% of 30,000, they bore these tiny little classified markings, which is, as you described, a C with parentheses, correct?
Correct.
Okay. It is certainly possible that a busy person who has sent and received over 30,000 emails just might miss this marking of a C with parentheses. It is possible, correct?
Correct.
Okay. So let me now just conclude by stating what some of my colleagues have, which is there's just the strongest whiff of hypocrisy going on here. The American public might be interested in knowing that all members of Congress receive security clearances just for being a member of Congress. We get to have private email servers. We get to have private email accounts. We can use multiple devices. We can take devices overseas. And really, at the end of the day, when the American people look at this hearing, they need to ask themselves this question: do they trust the biased, partisan politicians on this committee who are making statements based on evidence we have not reviewed, or do they trust the distinguished FBI director? I would trust the FBI director. I yield back.
Thank you. We'll now recognize the gentleman from Florida, Mr. Micah, for 5 minutes.
Thank you, Mr. Chairman. Director, how long did you investigate this matter?
Just about a year.
A year. And do you believe you conducted a legitimate investigation?
Yes, sir.
And it was a legitimate subject that was something that you should look into. You had that responsibility, is that correct?
Yes.
We have a responsibility to hear from you on the action that you took. This weekend and well, tomorrow we'll go back to our districts and we have to explain to people, albeit a couple of cafes where I see folks and meetings, and they're going to ask a lot of questions about what took place. Have you seen the Broadway production Hamilton?
Not yet. I'm hoping to.
I haven't either, but I understand it won the choreography Tony Award. I think you and others know that. The problem I have in explaining to my constituents is what's come down. It almost looks like a choreography. Let me just go over it real quickly with you. Last Tuesday, not this week, 1 week ago, former President Clinton meets with the Attorney General in Phoenix. The next Friday, last Friday, Mrs. Lynch, the AG, says she's going to defer to the FBI on whatever you came up with. On Saturday morning, I saw the vans pull up. This is this past Saturday, and you questioned Secretary Clinton for 3 hours. Is that, I guess that's correct?
3.5 it went.
Okay. And then on Tuesday morning, the morning after July 4th, we watched in our office. I had my interns. I said, come in. We've got the FBI director. Let's hear what he has to say. We're all kind of startled. And you basically said you were going to recommend not to prosecute, correct?
Mm-hmm. Yes, sir.
And then Tuesday, well, we had President Obama and Secretary Clinton arrive in Charlotte at 2 o'clock, and shortly thereafter, we had the Attorney General was closing the case. This is rapid fire. I mean, now, my folks think that there's something fishy about this. I'm not a conspiracy theorist, but there are a lot of questions on how this came down. I have questions about how this came down. Did you personally interview the secretary on Saturday morning?
I didn't personally, no.
And how many agents did?
I think we had 5 or 6 in the...
Did you talk to all of those agents after the interview?
I did not speak to all of them, no.
Did she testify or talk to them under oath?
No.
She did not. Well, that's a problem. But
no, it's still a crime to lie to us.
I know it is. Do you have a transcript of that?
No, we don't record our...
Do you have a 302, I guess it's called analysis?
I do. I don't have it with me, but I do.
Did you read it?
Yes.
You did. Can we get a copy of it since the case is closed?
I don't know the answer.
I would like a copy of it provided to the committee. I would like also for the last 30 days, any communications between you or any agent or any person in the FBI with the Attorney General or those in authority in the Department of Justice on this matter. Could you provide us with that?
We'll provide you with whether we can under the law and under our policy. It'll actually be easy in my case.
Mm-hmm. You see the problem that I have, though, is I have to go back and report to people what took place.
Sure.
Now, did you write the statement that you gave on Tuesday?
Yes.
You did. And did you write, and you said you didn't talk to all of the agents, but all of the agents, did they meet with you? And then, is that the group that said that we all vote to not recommend prosecution?
Well, yeah, I did not meet with all of the agents. I've met with, well, I guess I've met with all of them.
We're getting the word that it was like unanimous out of FBI that we don't prosecute.
Or what's your question, Congressman?
Well, again, I want to know who counseled you. You read their summary. Okay, she was not under oath. And it appears, I mean, members have cited here where she lied or misled to Congress, which will lead now to the next step of our possibly giving you a referral on this matter. You're aware of that?
Yes, someone mentioned that earlier.
And that probably will happen. Thank you for shedding some light on what took place.
Can I, Mr. Chairman, can I
go ahead.
Respond just very briefly? I hope what you'll tell the folks in the cafe is, look me in the eye and listen to what I'm about to say. I did not coordinate that with anyone. The White House, the Department of Justice, nobody outside the FBI family had any idea what I was about to say. I say that under oath. I stand by that. There was no coordination. There was an insinuation of what you were saying that I don't mean to get strong in responding, but I want to make sure I was definitive about that.
Thank you,
sir.
Thank you. We'll now recognize the gentlewoman from the Virgin Islands, Ms. Plaskett, for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here. Director Comey, I would rather be here talking with you about the FBI's investigation and their resources to those individuals who are acting under color of law, who have apparently committed egregious violations in the killings that we've seen in the recent days. But instead, Mr. Chairman, I'm sitting here and I've listened patiently as a number of individuals have gone on national TV and made accusations against Director Comey, both directly and indirectly, because he recommended against prosecution based upon the facts. I've listened just very recently here in this hearing as my esteemed colleague from Florida tries to insinuate the condensation of an investigation into 1 week that actually occurred over a much, much longer period of time. And using that condensation and conspiracy theory to say that there's some orchestration. And that they have accused Mr. Director Comey of basing his decision on political considerations rather than the facts. I've heard chuckles and laughter here in this hearing, and I don't think there's anything to be smiling or laughing about. Because I want to say something to those individuals who are chuckling and laughing and making attacks on Director Comey for doing his job. You have no idea who you're talking about. Your accusations are completely off base, utterly offensive to us as American people. I know this because I've had the honor of working for Director Comey during my own service at the Department of Justice. From 2002 to 2004, I served as senior counsel to the Deputy Attorney General. I worked with both the Deputy Attorney General, Larry Thompson, and Deputy Attorney General Jim Comey when he became deputy as a staff attorney. And I know from my own experiences that Director Comey is a man of impeccable integrity. There are very few times when you as an attorney or as an individual can work with individuals or a gentleman who is completely that, someone who is above the fray. Anyone who suggests or implies that he made his recommendations on anything but the facts simply does not know James Comey. We've used the term no reasonable prosecutor. Well, I know that James Comey doesn't act as what a reasonable prosecutor was due, because he is the unyielding prosecutor. He is the prosecutor who does what is politically not expedient for himself, his staff, but for the law. And I'm not the only person in this hearing, in this committee, who's worked with Director Comey or for him. Representative Gowdy himself also commended Director Comey, and he said this, and I quote, "I used to work with him. I think Comey is doing exactly what you want. He's doing a serious investigation behind closed doors, away from the media's attention, and I'm going to trust him until I see a reason not to." Representative Gowdy referred to Director Comey as honorable and apolitical. He said, "This is exactly what you want in law enforcement." Well, it's exactly what you want in law enforcement until the decision is not the decision that you want. Director Comey, Chairman Chaffetz, as it was said by one of my colleagues, went on television and accused you of making, quote, a political calculation. He said that your recommendation was nothing more than, quote, a political determination in the end. I'm going to ask you, how do you respond to that? Were your actions in any way, shape, or form governed by political consideration?
No, not in any way.
And did anyone with Secretary Clinton's campaign or the administration influence your recommendation for political reasons?
No, they didn't influence it in any way.
I'm going to take you at your word, because I know, and those who will go through the record of your long tenure as a career prosecutor, and they look at examples, will see that you have taken decisions that have not been that, which your supervisors, which the president, which others have wanted you to take. As a fellow prosecutor who believed that the facts must come above politics, I'm thankful that we have you. And Director Comey, I want to thank you for your service to our country, and you have our support. We would like to see as much documents, and I'm grateful that you want to keep the transparency so that the American public can understand the difference between what they hear in the media and the elements of a crime necessary for criminal prosecution. Thank you.
Thank the gentlewoman. We'll now recognize the gentleman from Texas, Mr. Farenthold, for 5 minutes.
Thank you very much, Director Comey. I want to talk a little bit about cybersecurity. State Department's Inspector General report detailed instances of multiple attacks on Secretary Clinton's computer, as well as her replying to suspicious email from the personal account of the Undersecretary of State. Director, you said that hostile actors successfully gained access to the commercial email accounts of people Secretary Clinton regularly communicated with. In the case of the Romanian hacker Guccifer, according to accessing Sidney Blumenthal's account, and that's been public for some time. During your investigation, were there other people in the State Department or that regularly communicated with Secretary Clinton that you can confirm were successfully hacked?
Yes.
And were these folks that regularly communicated with the Secretary?
Yes.
And were you able to conclude definitively that the attempted hacks referenced in the IG report were not successful?
We were not able to conclude that they were successful. I think that's the best way to say it.
All right. So while you said that given the nature of Clinton's server, you would be unlikely to see evidence one way or the other of whether or not it had been successfully hacked, how many unsuccessful attempts did you uncover? Did you find any there?
There were unsuccessful attempts. I don't know the number off the top of my head.
Do you have an idea? Were they from foreign governments? Where did they come from?
I want to be careful what I say in an open setting, and so we can give you that information, but I don't want to give any foreign government's knowledge of what I know. So all
right, but would you be so far as to say they probably weren't American high school students fooling around?
Correct. It was not limited to criminal activity.
During your investigation, did you or anyone in the FBI interview the hacker Guccifer?
Yes.
And he claimed he gained access to Sid Blumenthal's email account and traced him back to Clinton's private server. Can you confirm that Guccifer never gained access to her server?
Yeah, he did not. He admitted that was a lie.
All right. Well, at least that's good to hear. All right. Section 793 of Title 18 of the United States Code makes it a crime to allow classified information to be stolen through gross negligence. Were you to discover that hostile actors had actually gotten into Secretary Clinton's email, would that have changed your recommendation with respect to prosecuting her?
Unlikely, although we didn't consider that question because we didn't have those facts.
All right, I want to go back to the question of intent real quick for just a second. I'm a recovering attorney. It's been decades since I actually practiced law. But you kept referring to she had to know it was illegal to have the requisite criminal intent. I was always taught in law school, and I don't know where this changed, that ignorance of the law was no excuse. If I'm driving along at 45 miles an hour and didn't see the 35-mile-an-hour speed limit, I was still intentionally speeding even though I didn't know it. Now, I might not have had the requisite criminal intent if maybe my accelerator were jammed or something like that. But even though I didn't know the law was 35, I was driving 45, I'm going to get a ticket. And I'm probably going to be prosecuted for that. So how can you say ignorance of the law is an excuse in Mrs. Clinton's case?
Well, the comparison to petty offenses I don't think is useful, but the question of ignorance of the law is no excuse. But here's the distinction. You have to have general criminal intent. You don't need to know what particular statute you're violating, but you must be aware of the generally wrongful nature of your conduct.
So Congress, when they enacted that statute, said gross negligence. Yep. That doesn't say intent. So what are we going to have to enact to get you guys to prosecute something based on negligence or gross negligence? So we're going to have to add, and oh, by the way, we really do mean you don't have to have intent there?
That's a conversation for you all to have with the Department of Justice, but it would have to be something more than the statute enacted in 1917, because for 99 years they've been very worried about its constitutionality.
All right. Well, I think that's something this committee and Congress as a whole, the Judiciary Committee, that Mr. Chaffetz and I also sit on, will be looking at it. And I was on television this morning, and I just want to relay a question that I received from a caller into that television commercial. And it's just real simple. Why should any person follow the law if our leaders don't? And we can argue about intent or not, but you laid out the fact that she basically broke the law, but you couldn't prove intent. Maybe I'm putting words in your mouth, but I do want to know why any person should follow the law if our leaders don't have to. And maybe that's rhetorical, but I'll give you an opportunity to comment on that.
Yeah, that's a question I'm no more qualified to answer than any American citizen. It's an important question. In terms of my work, in my world, my folks would not be, one of my employees would not be prosecuted for this. they would face consequences for this. So the notion that it's either prosecute or you walk around smiling all day long is just not true for those people who work for the government. The broader question is one for a democracy to answer. It's not for me.
And I guess the ultimate decision as to whether or not Ms. Clinton works in government or not is in everybody's hands.
I thank the gentleman. Yield back. We'll now recognize the gentleman from Pennsylvania, Mr. Boyle, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director Comey, for appearing, especially on such short notice. I want to share with you actually something a friend of mine was expressing when watching your press conference 48 hours ago, and this is someone who's not in any way political. In fact, probably typical of most American citizens today in being depressed about the remarkable level of cynicism we have in our government, that specifically those of us who are in government make decisions first and foremost because of the party hat we wear and not necessarily based on the facts and the evidence. And he texted me after watching your 15-minute presentation, oh, it's nice to see a real pro. You can tell that he would make the decision based on the facts and the evidence and not what party he wears. I think that's so important if we're ever going to get to a place in this country where we restore some of the faith that we had in government. If you look at the poll numbers from 1940s and 1950s, and you look at faith in government among the American public, and you look at those numbers today, the numbers today are anemic. They're nowhere near the levels that they were decades ago. So for that, I want to say thank you, and I think that many citizens have the same impression. When I first met you a couple years ago at a weekend session in Colonial Williamsburg, you might remember that we had a discussion about my biggest concern frankly, facing the security of the American people, and that is the possibility of a lone wolf terrorist, someone becoming self-radicalized and acting based on that. We had an exchange that I'll keep private, but I think I can characterize that you share my concern. I'm just thinking for the last 2.5 hours that we've been here, we've had the FBI director asking questions on this matter when, frankly, I would have much rather your time spent dealing with the potential of lone wolf terrorists and other coordinated attacks that we face. But since this is the Oversight and Government Reform Committee, trying to find something that we can now take and possibly use in a systemic way, not just the celebrity of Secretary Clinton and the fact because it involves her, let's face it, that's the reason why we're here. But I want to try to take something out of this very expensive and long investigation and try to use it in a productive way toward reforming government that possibly we can get something good out of it. So toward that end, I'm really concerned about this issue of up-classification. Because it seems as if, and I was not aware of this until the investigation, there is quite a strong discrepancy between not just former Secretary Clinton, but even former Secretary Powell, what he thinks should be classified, and then what is classified after the fact. And I think if I'm right, there were some 2,000 emails that were up-classified. I was wondering if you could speak to that.
Yeah, it actually was not a concept I was real familiar with before this. It's the notion that something might not have been classified at the time, but that in hindsight, as a government agency considers releasing it, they raise the classification level to protect it because it's a candid assessment of a foreign leader or something like that. I think it is largely a State Department thing because their diplomats will often be conversing in an unclassified way that when they look at releasing it in response to a FOIA request, they think it ought to be protected in some fashion. But honestly, I kind of pushed those to the side.
Right.
The important thing here was what was classified at the time. That's what matters.
Right. And that, for a law enforcement official, matters. But I'm just wondering if you could share with us any of your impressions about a system that exists where there is such gray area and discrepancy in what is classified and what's not. And if you or your agents had any suggestions for us, either in government reform, or I happen to be in the Foreign Affairs Committee that is oversight of State Department, do you believe that this is a matter that we should take up where there is such discrepancy in what's classified, what's not classified? I think of one example, Ambassador Ross put something in a book that wasn't classified and then was up classified after the book came out. Well, what good does that Does that do us as a country in terms of trying to protect the intelligence of the United States?
Yeah, I'm not an expert in this up-classification business, but I do suspect it would be a fertile ground for trying to figure out whether there are ways to do it in a more predictable, reliable way.
Yeah. Well, thank you again for your service, and I yield back my time.
Thank the gentleman. We'll now recognize the gentleman from Georgia, Mr. Heiss, for 5 minutes.
Director Comey, your statement on Tuesday clearly showed that Secretary Clinton not only was extremely careless in handling classified information, but that also any reasonable person should have known better, and that also in doing so she put our national security at risk with her reckless behavior. So it seems to me that the American people are only left, based on your assessment, with just a few options. Either Secretary Clinton herself is not a reasonable person, or she is someone who purposefully, willfully exhibited disregard for the law, or she is someone who sees herself as above the law. And to muddy the water even further, after listening to you lay out the facts of the investigation, much of what you said directly contradicted her in previous statements that she had made. I think it's all this compiled, connecting the dots that so many American people are irate that after all of this, there was not a recommendation for Secretary Clinton to be prosecuted. Now, I do greatly appreciate the fact that you came out with much more information on this than you would have in other cases. And I think that was the right thing to do. Undeniably, this is not a typical case. This is something of great public interest. Obviously, the subject of the investigation, former Secretary of State, former Senator, and all those things that we have talked about, former First Lady and so forth. And in addition to this, her husband, who happens to be the former President of the United States, is meeting privately with the Attorney General right before all of this interview takes place. Obviously, this is very suspicious, just the optics of it all. And at the same time that you're coming out, or more or less the same time that you are announcing the decision, Secretary Clinton is flying around in Air Force One with the president doing a campaign event. I mean, there's nothing about this case that's ordinary. There's nothing about the subject that's ordinary. So let me ask you this, Director. Did Secretary Clinton, in fact, comply with the department's policies or the Federal Records Act?
I don't think so. I know you have the State Inspector General here who's more of an expert on all the department's policies, but at least in some respects, no.
So keeping the servers at home and all these types of things obviously is not in compliance with the department's policies.
Yes, and I've read the Inspector General's report on that. That's part of the reason I can answer that part with some confidence.
Okay, and yet she said publicly that she fully complied. So there again is another issue. If you had the same set of facts, but a different subject, a different individual involved, say just an average ordinary State Department employee or an anonymous contractor, what would have been the outcome?
I'm highly confident there would be no criminal prosecution, no matter who it was. There would be some range of discipline. They might get fired, they might lose their clearance, they might get suspended for 30 days. There'd be some discipline, maybe just a reprimand. I doubt it. I think it'd be higher on the discipline spectrum, but some sort of discipline.
So is it your opinion that there should likewise be some discipline in this case?
Yeah, that's not for me to say. I can talk about what would happen if it was a government employee under my responsibility.
Well, then what you're laying out is that there is a double standard. For someone else, a different subject, an anonymous contractor or someone at the State Department, there would absolutely be discipline, but because of who the subject is, you're not willing to say there should be discipline. So there's, again, this whole issue. This is what the American people are so upset about. Let me say that when you stated that no reasonable prosecutor would pursue this case, is that because the subject of this investigation was unique?
No. There's no double standard there. And there's no double standard either in the sense that if it was John Doe, former government employee, you'd be in the same boat. We wouldn't have any reach on the guy. He wouldn't be prosecuted.
But he would have some discipline.
Well, not if he had left government service.
Had they lied about having servers, had they lied about sending and receiving classified emails, had they lied about not deleting those emails to the public, had they lied about not having any marked classified, the statements are clearly documented, and you're saying that an average person would experience discipline by your own words, but Secretary Clinton does not deserve to be disciplined.
The gentleman's time has expired, but the director may answer if he wants to.
An average employee still in government service would be subject to a disciplinary process. Now, if they'd left, you'd be in the same boat.
Gentleman from Georgia yields back. The chair will now recognize his friend from Vermont, Mr. Welch.
Thank you very much, Mr. Chairman. Thank you, Director Comey. A prosecutor has really awesome power. The power to prosecute is the power to destroy, and it has to be used with restraint. You obviously know that. You're being asked to, you have had to exercise that responsibility in the context of a very contested presidential campaign, enormous political pressure. You had to do it once before. And I go back to that evening of March 10, 2004, when the question was whether a surveillance program authorized after 9/11 by President Bush was going to continue, despite the fact that the Justice Department had come to an independent legal conclusion that it actually violated our constitutional rights. That's a tough call because America was insecure. The President was asserting his authority as Commander-in-Chief to take an action that was intended to protect the American people. But you and others in the Justice Department felt that whatever that justification was, the Constitution came first, and you were going to defend it. And as I understand it, you were on your way home and had to divert your drivers to go back to the hospital to be at the bedside of a very sick, at that time, Attorney General. And you had to stand in the way of the White House Chief of Staff and the White House Counsel. I'm not sure that was a popular decision or one that you could have confidently thought would be a career booster. But I want to thank you for that. Fast forward, we've got this situation of a highly contested political campaign. And there is substantive concern that's legitimate by Democrats and Republicans for independent political reasons. But you had to make a call that was based upon your view of the law, not your view of how it would affect the outcome of who would be the next Commander-in-Chief. Others have asked this for you, but I think I'm close to the end. I want to give you a chance to just answer, I think, the bottom line questions here. Had you, after your thorough investigation, found evidence that suggested that criminal conduct occurred, is there anything, or anyone that could have held you back from deciding to prosecute?
No. I don't have the power to decide prosecution, but I'd have worked very hard to make sure that a righteous case was prosecuted.
And you would have made that recommendation to the Attorney General?
Yes.
Was there any interference, implicit or explicit, from the President of the United States or anyone acting on his behalf to influence the outcome of your investigation and the recommendation that you made?
No.
Was there anyone in the Hillary Clinton campaign or Hillary Clinton herself who did anything directly or indirectly to attempt to influence the conclusion that you made to recommend no prosecution?
No.
At this moment, after having been through several hours of questioning, is there anything in the questions you've heard that would cause you to change the decision that you made?
No. I don't love this, but it's really important to do. and I understand the questions and concerns. I just want the American people to know we really did this the right way. You can disagree with us, but you cannot fairly say we did it in any kind of political way. We don't carry water for anybody. We're trying to do what the right thing is.
Well, I very much appreciate that, and I very much appreciate that it takes strong people of independent judgment to make certain that we continue to be a nation of laws. Mr. Chairman, just one final thing, and I'll yield to Mr. Cummings. We've got a political debate where a lot of these issues that are going to be, that have been raised are going to be fought in the campaign. And we've got Secretary Clinton who's going to have to defend what she did. She's acknowledged it's a mistake. We've got that great constitutional scholar, Mr. Trump, who's going to be making his case about why this was wrong. But that's politics. That's not really having anything to do with the independence of prosecutorial discretion. Thank you, Director Comey. And I yield whatever additional time I have to Mr. Cummings.
I think the gentleman's going to yield back. I spoke with Mr. Cummings, so. Yeah. We'll now recognize the gentleman from Kentucky, Mr. Massey, for 5 minutes.
Thank you, Mr. Chairman. And thank you, Director Comey, for showing up and your willingness to be transparent and answer a lot of unanswered questions. A few hours before this hearing started, I went onto social media and asked people to submit questions, and I've got over 500 questions, and I don't think I'll get to ask them all in these 5 minutes. But I'm sure you'll be willing to answer them. One of the common themes that I came in here to ask, but I realize it's not the right question now, is what's the difference between extremely careless and gross negligence? But in the process of this hearing, what I'm hearing you say is that's not what your reluctance is based on. It's not based on a reluctance to prosecute, by the way. Your reluctance to recommend a prosecution or an indictment is not based on parsing those words. It's based on your concern for this statute, with this statute. Is that correct from your opening statement?
It's broader than that, actually, the statute, and it fits within a framework of fairness, and also my understanding of what the Department of Justice has prosecuted over the last 50 years.
So when you say a reasonable prosecutor wouldn't take this case, it's not because you don't think she made, that she lied in public or that maybe she was negligent. It's because you have concern with the prosecutorial history of this statute.
And not just that statute, but also 1924, which is the misdemeanor. I also don't see cases that were prosecuted on facts like these. So both 793 and 1924.
But you did find one prosecution. And has it been overturned by the Supreme Court?
No, there was one time it was charged in an espionage case, and the guy ended up pleading guilty to a different offense, so it was never adjudicated.
So, your concern is with the negligence threshold, that you think it requires mens rea or knowing the crime. But in all 50 states, isn't there a negligent homicide statute, and aren't people prosecuted for that all the time? And doesn't the Supreme Court and all the courts below that uphold those prosecutions just on the basis of negligence?
I don't know whether all 50 states. I think negligent homicide and manslaughter statutes are relatively common.
Okay, so but don't all 50 states have something like that, and aren't those sustained in the upper courts, those convictions?
I don't know whether all 50 states have something like that, but again, I think it's very common, and I think those are sustained.
So don't we have a history of, you implied that the American judicial system doesn't have a history of convicting somebody for negligence, but don't we in other domains of justice?
We do. I know the federal system best. There are very few in the federal system. They're mostly, as we talked about earlier, in the environmental and food and drug administration area.
Thank you. Now I want to ask another question that's come up here. You've basically related to us that this information, this top secret or classified information, got into these email chains because of conversations people were having. They were relating what they heard before in other settings. Is that correct?
No. Maybe in some cases, but it was people having an email conversation about a classified subject.
Okay, so they were having an email conversation, but how in this email conversation did this bore marking show up? Like, if they're not sophisticated enough, as you said before, even Hillary Clinton wasn't sophisticated enough to recognize a bore marking to see with the parentheses for confidential or classified, if they weren't that sophisticated, how did they recreate that bore marking in their emails when they're having these discussions?
Yes, a lot of what ended up on Secretary Clinton's server were stuff that had been forwarded up a chain and gets to her from her staff, a lot of that forwarding, and then she comments sometimes on it. Someone down in the chain, in typing a paragraph that summarized something, put a portion marking C, on that paragraph.
Can you, doesn't it take a lot of intent to take a classified document from a setting that's authorized and secure to one that's not? Wouldn't it require intent for somebody to recreate that classification marking in an unsecure setting?
I don't know. It's possible, but also I could.
Do they accidentally type open parentheses C, close parentheses, and indent the paragraph?
Oh no, you wouldn't accidentally type.
Right. So
someone
it takes
down
intent.
The chain.
Right.
Someone down the chain.
Okay. So this is my question: is someone down the chain being investigated? Because they had the intent clearly. If they had the sophistication which Hillary Clinton, you insinuate, may have lacked, if they had the sophistication to know what this bore marking was, they had to have the intent to recreate it or the intent to cut, copy, paste from a secure system to an unsecure system. Wouldn't that be correct?
Potentially, but we're not. There's not an open criminal investigation of that person way down the chain.
Shouldn't there be?
A criminal investigation?
An investigation if there's intent, which is what I mean, and I think you may be reasonable in requiring that threshold, but don't we treat everybody the same, whether at the top of the chain or the bottom of the chain?
Sure, you want to if the conduct is the same, but we did not criminally investigate whoever started that chain and put the C on on those paragraphs. We did.
Okay, I would suggest maybe you might want to do that, and I will yield back to the chairman.
I thank the gentleman. We'll now recognize the gentlewoman from Michigan, Ms. Lawrence, for 5 minutes.
Director Comey, how many years have you been the director?
3 years. I know the exact day count, I think, at this point.
So how many cases have you investigated approximately that you had to render a decision?
The Bureau investigates tens of thousands of cases. The director only gets involved in a very small number of them.
So about how many?
I think I've been deeply involved in probably 10 to 20.
Have you ever been called before Congress on any of those other decisions?
No, this is the first time.
Thank you. There are some Republicans who support you. Not surprisingly, they're the ones who actually know you. And I have a letter here, and I would like to enter into the record from Richard Painter, Mr. Chair. He was President Bush's chief ethics lawyer. And may it be entered into the record?
She's asking unanimous consent without objection, so ordered.
Mr. Painter refers to Mr. Comey as a man of, and I quote, a man of the utmost integrity who calls the shots as he saw them without regard to political affiliation or friendship. He states, and I quote, throughout the FBI investigation of Secretary Clinton's email server, I have been convinced that the director would supervise the investigation with being impartial and strict adherence to the law, as well as prosecutorial precedent. He also adds, although I'm aware of very few prosecutions for carelessness in handling classified information as opposed to intentional disclosure, I knew that the director would recommend prosecution in any and all circumstances where it was warranted. I cannot think of someone better suited to handle such a politically sensitive investigation. Finally, and I quote, I urge all members of the United States Congress to stop from inferring in specific decisions, particularly those involving political allies or opponents. During my tenure in the White House, there were very unfortunate allegations that powerful senators sought politically motivating firing of United States attorney. Whether or not such allegations were true, it is imperative, and I'm still quoting, that members of the Senate or the House never again conduct themselves in a matter where such interference could be suspected. And I want to be on the record, I wholeheartedly agree with Mr. Painter. Director, you have demonstrated yourself, you sat here and asked the questions, and I would never oppose to finding the answers to any situation that is directly related to federal agencies, which we on this committee are responsible for. But I want to be clear that Congress has no business interfering with these types of decisions that are coming in your responsibility. These type of attacks are not only inappropriate, but they're dangerous. They're dangerous because they could have a chilling effect on the future investigations. And I asked that question, how long have you been in this position? How many times have you made decisions and they were not pulled in 24 hours before this committee? How many times? And then we say it's not political. And you have said repeatedly, regardless of who it was, you conducted the investigation as required under your responsibility. And here you have Republicans who are saying you are an honorable man. And till this day, I have not heard any complaints of your judgment. So I sit here today as a member of Congress on the record that the slippery slope that we're seeing today in this hearing, I want every member to be cautious of what we're saying, that in America, when we have investigations, that we will allow our own elected Congress and Senate to make this a political agenda to attack, but only if it's in their agenda. This goes for Democrats and Republicans. We are not here to do that. Thank you, and I yield back my time.
Thank the gentlewoman. We'll now recognize the gentleman from Iowa, Mr. Blum.
Thank you, Mr. Chairman. Thank you, Director Comey, for being here today, and thanks for hanging in there till every last question is answered. I'm not a lawyer. That's the good news. I'm a career businessman. I've spent most of my career operating in the high-tech industry. And today I've heard words such as common sense, reasonable person, carelessness, judgment, or lack thereof. I like these words. I understand these words. I think the average American does as well. So I'd like to focus on that. Last Tuesday, Director Comey, you said, and I quote, "None of these emails should have been on any kind of an unclassified system, but their presence is especially concerning because all these emails were housed on unclassified personal servers, not even supported by full-time security staff, like those found at agencies of the United States government, or even with a commercial email service such as Gmail." Director Comey, my small Iowa business doesn't even use Gmail for our email because it's not secure enough. I know some security experts in the industry. I check with them. The going rate to hack into somebody's Gmail account, $129. For corporate emails, they can be hacked for $500 or less. If you want to hack into an IP address, it's around $100. Now, I'm sure the FBI can probably do it cheaper. This is the going rate. Director Comey, are you implying in that statement that the private email servers of Secretary Clinton's were perhaps less secure than a Gmail account that is used for free by 1 billion people around this planet?
Yes, and I'm not looking to pick on Gmail. Their security is actually pretty good. The weakness is in the individual users. But yes, Gmail has full-time security staff and thinks about patching and logging and protecting their systems in a way that was not the case here.
I'd like to ask you, what kind of judgment, we talked a lot about judgment today, does this decision to potentially expose to hackers classified information on email service that's less secure than Gmail, your words, what does that suggest to you? What type of judgment does that suggest to you?
It suggests the kind of carelessness that I talked about.
In August of last year, Secretary Clinton was asked by Ed Henry of Fox News whether she had wiped her entire server, meaning did she delete all the emails on her server? Her response, "You mean with a cloth?" March of 2015, during a press conference, Secretary Clinton assured us her private email server was secure, saying the server was on private property guarded by the Secret Service. Now, this would be laughable if it wasn't so serious. I know, you know, my constituents in eastern Iowa know you don't need to be a cat burglar to hack into an email server, and you don't need a cloth to wipe a server clean. One would think that a former United States Senator, one would think that a former Secretary of State would know this as well. Would you agree with that statement?
You would think, although as I said before, one of the things I've learned in this case is that the Secretary may not have been as sophisticated as people assume. She didn't have a computer in her office at the State Department, for example. So I don't think, so I would assume the same thing about someone who'd been a senator and a high-ranking official. I'm not sure it's a fair assumption in this case.
In your opinion, Director Comey, did Secretary Clinton know that a server could in fact be wiped clean electronically and not with a cloth?
Well, I assume that I don't.
Would you assume she knows that?
I would assume that it was a facetious comment about a cloth, but I don't know. I don't know in particular on that one.
Would you also assume, Director, that Secretary Clinton knew that a server could be wiped clean electronically, that it could be hacked electronically, not physically? You don't need a cat burglar to hack a server. Would you assume, would that be reasonable to assume she knows that?
To some level, it would be reasonable, to some level of understanding.
Then once again, for someone who knew these things, or we assume to some level she knew these things, what kind of judgment does a decision to expose classified material on personal servers suggest to you? What type of judgment?
Well, again, it's not my place to assess judgment. I talk in terms of state of mind, negligence in particular. I think there was carelessness here, and in some circumstances, extreme carelessness.
Was her server hacked?
I don't know. I can't prove that it was hacked.
So that answer says to me it could have been hacked.
Sure, yeah.
And if it was hacked, potentially damaging material, damaging to American secrets, damaging to American lives, could have been hacked, could have been exposed, correct? Yeah. Lives could have been put at risk if that server was indeed hacked.
I'm not prepared to say yes as to that last piece. That would require me going into, in a way I can't hear the nature of the classified information, but there's no doubt that it would have potentially exposed information that was classified. Information is classified because it could damage the United States of America.
So it could have happened. The FBI just isn't aware.
Correct.
Thank you very much. Thank you for being here. I yield back the time I do not have.
Thank the gentleman. Now recognize the gentlelady from New Jersey, Ms. Watson-Coleman, for 5 minutes.
Thank you, and thank you, Director. I've got a number of questions, so I'm going to zip through these.
Okay.
This is the question I'm going to ask you, and you may not even have the answer to it because you may not have known this. This is about the classification marking issue that you've been asked about earlier. According to the State Department, which addressed this issue yesterday, a spokesman said that the call sheets appear to bear classified markings, but this was actually a mistake. To quote, "Generally speaking, there's a standard process for developing call sheets for the Secretary of State. Call sheets are often marked, but it's not untypical at all for them to be marked at the confidential level prior to a decision by the Secretary that he or she will make that call. Oftentimes, once it is clear the Secretary intends to make a call, the Department will then consider the call sheet SBU, sensitive but unclassified or unclassified altogether, and then mark it appropriately and prepare for the Secretary's use in actually marking the call. The classifications of a call sheet, therefore, is not necessarily fixed in time, and staffers in the Secretary's office who are involved in preparing and finalizing these call sheets, they understand that. Given this context, it appears that markings in the documents raised in the media reports were no longer necessary or appropriate at the time they were sent as an actual email. Those markings were a human error. They didn't need to be there. Did you know this?
No.
Thank you, Mr. Director. Can you tell me, based upon your information, has there been, and is there any evidence that our national security has been breached or at risk as a result of these emails and their being on this server? Is there any evidence?
There's no direct evidence of an intrusion.
Thank you very much. I have to tell you that while I think that this should conclude this discussion, I know we're going to hear this issue ad nauseum. But I am concerned about another issue that I think really is resonating with the people in this country. And that issue has to do with experiences that we had just the last 2 days. Mr. Director, I want to bring this up for your consideration because I want to ask you, what can the FBI do in this issue? This morning we woke up to another graphic and deeply disturbing video that actually brought me to tears when my staff played it for me, wherein a Minnesota woman's boyfriend has been shot as her young child sat in the back seat after apparently telling the officer he was licensed to carry a weapon. He had it on him and was going to reach for his identification. Just the other day, there was an incident in Baton Rouge involving a Mr. Alton Sterling, an African-American man who was shot while pinned to the ground by police officers in Baton Rouge. An interaction tape by two bystanders with cell phones captured this. So I think that we've got an issue here, an issue of real national security. And I want to ask you, Mr. Director, do we have an opportunity to direct our time and resources in your department to those issues? Is it not important that we say their names to remind people of the loss of a Tamir Rice, to an Eric Garland, to an Alton Sterling, to a John Crawford III, to a Michael Brown, to a Walter Scott, and even a Sandra Bland? Deaths in the hands of police custody or by police happening? Are these not happening at an alarming rate? And is this not a legitimate space for the FBI to be working in?
Yes is the emphatic answer. Those are incredibly important matters. As you know, the FBI spends a lot of time on them because they're very, very important. We have an investigation open on the Baton Rouge case. I was briefed this morning on the Minnesota case. And I would expect we'll be involved in that as well. It's an important part of our work.
Do you feel that you have the sufficient resources from the legal imperative to the funding to address these cases and what seems to be a disturbing pattern in our country today?
I'm a bad bureaucrat, but I believe I have sufficient resources, and we are applying them against those situations because I believe the individual cases matter enormously, but also the people's confidence in law enforcement is one of the bedrocks of this great country of ours. So I have the resources, and we're applying them to.
And in addition, we believe that our law enforcement is, by and large, of high integrity and has a desire to keep us protected and safe. But when we find out that there are these occasions, and when there's an indication that there's a pattern that is taking place in this country, we have a responsibility to ensure that everyone in this country is safe. And simply because you're a black man or a black woman does not make you a target. Thank you. I yield back my time.
Thank the gentlewoman. We'll now recognize the gentleman from North Carolina, Mr. Walker.
Thank you, Mr. Chairman. Thank you, Director Comey, for being here. There are a few things in this town that people agree on both sides of the aisle, and one of them is your reputation. I'm reminded of the passage in James, swift to hear, slow to speak, and slow to wrath. I am a little disappointed in some of the things that I've heard from my colleagues about some of the attacks on your character and your integrity. I haven't heard those, and I hope that we have you've not experienced that. I also struggle with the change of heart that we're hearing today because I have a list of elected officials who have questioned your investigation, even attacked it. In fact, the former President Clinton said this is a game. In fact, just last Friday, Ms. Wasserman Schultz, Congresswoman Wasserman Schultz, said Secretary Clinton is not the target of this investigation or whatever you want to call it. My question to you today is, do you feel like this has been a Republican witch hunt?
This
hearing?
No.
Okay, thank you for
I said
clearing
at the
that.
beginning, I understand people's questions and interests. And I'm a huge fan of transparency. I think that's what makes our democracy great.
And I think goes to one of the reasons of why you are so respected. To me, this hearing is about understanding and disseminating the facts and how you saw them and how the American public sees them, and specifically in the areas of where there was wrongdoing admitted under your investigation, where there was obviously breaking the law, but also some cover-ups. Did Congress ask you to pursue this investigation?
No, it was a referral from the Inspector General of the intelligence community.
So it wasn't Republicans either, was it?
No.
How did you go about collecting the evidence?
We used the tools that we normally use in a criminal investigation.
Did you receive a congressional referral for all the information that you collected?
Not to my knowledge.
Well, then, one of the things that I'm struggling with, or that I would like to know specifically, is under oath, Ms. Clinton made these 3 comments that we now know are untrue in the Benghazi hearing. Number 1, she's turned over all her work-related emails. Number 2, telling the committee that her attorneys went through every single email. And then finally, and probably the one that continues to stick the most, there was, and I quote, "nothing marked classified on my emails," end quote. Now, earlier, when the chairman questioned you about this, you said something about needing a congressional referral recommendation. My question is, something of this magnitude, why, or can you help me understand why didn't it rise to your investigation, or someone bringing that to your knowledge as far as saying this is a problem, here she is, again, the Secretary Clinton lying under oath, specifically about our investigation?
Well, we, out of respect for the legislative branch being a separate branch, we do not commence investigations that focus on activities before Congress without Congress asking us to get involved. That's a long-standing practice of the Department of Justice and the FBI. So we don't watch on TV and say we ought to investigate that. Joe Smith said this in front of the committee. It requires the committee to say, we think we have an issue here. Would you all take a look at it?
But with all due respect, if you have the Secretary Clinton who is under oath speaking about your very investigation, and you've talked about your wonderful staff and certainly have no reason to deny that, why wouldn't that rise to the level of suspicion that here she is saying this under oath? I mean, lying under oath is a crime, is it not?
Yes.
And what's the penalty on that? That's considered perjury, right?
Perjury. It's a felony. I forget the exact. It's potentially years in prison.
But I don't understand. Would you help me understand why somebody wouldn't have tipped you off that she's talking about the very specific case under oath that you're investigating?
Well, there's a difference between us being aware of testimony and us opening a criminal investigation for potential perjury. Again, it's not this case in particular, but all cases. We don't do that without a committee saying we think there was an issue in testimony given in this separate branch of the government.
You also mentioned earlier, and it's been quoted several times, that no reasonable prosecutor would move forward with some of the facts. Is there any room at all that somebody would differ a little bit on the opinion? I know that former United States Attorney General Michael Mukasey said with the illegal server, it disqualifies for her from ever holding any federal office. So there are some people of high esteem that may differ, obviously not privy to the exact facts, but can you make any room? You said no reasonable person. Do you understand why the American people, or would you understand why other people may say that she has stepped across the line or broken enough law here that you would come to a different conclusion?
Sure, I respect different opinions. My only point is, and I said earlier, I smile because those folks are my friends. I've worked with them for a long time. None of those guys in my position, I believe, knowing what I know, would think about it differently. But I also respect that they have a different view from the outside.
Thank you, Mr. Chairman. Yield back.
I thank the gentleman. Now recognize the gentleman from California, Mr. Desaigner.
Thank you, Mr. Chairman. Director, I just want to thank you, as others have, and I know you don't need this, but I think the American people clearly need to hear it. You've done a wonderful job today, but there are moments in my political life, and as American, I despair for the future of this country, not often, but in those moments comes an individual like yourself, either by providence or good fortune or by the framework of the U.S. Constitution. I really believe you've served this country and all Americans well, irrespective of their party affiliation. So really two lines of questions, I should say. One is, and another colleague has brought this up, but you mentioned just previous testimony about the bedrock and the importance of public confidence in public safety institutions, yours and all's. So I just want to give you an opportunity. I think you've responded to this multiple times, but give you a little more opportunity because I think it's important for the American public to know that the system isn't rigged, that there are people such as yourself and the 15 individuals who worked on this case and others that do their job and believe in the Constitution of the United States. And if you have any further comments about comments that would say that the system's rigged and Americans should give up on the system.
No, one of the reasons I welcome this opportunity to have this conversation is I was raised by great parents who taught me you can't care what other people think about you. Actually, in my business, I have to and deeply do that people have confidence that the system's not fixed against black people, for rich people, for powerful people. It's very, very important that the American people understand that there really are people that you pay for with your tax dollars who don't give a rip about Democrats or Republicans or this or that, who care about finding out what is true. And I am lucky to lead an organization that is that way to its core. I get a 10-year term to ensure that I stay outside of politics, but in a way it's easy. I lead an organization that is resolutely apolitical. We are tough, aggressive people. If we can make a case, we'll make a case. We do not care what the person's stripes are or what their bank account looks like. And I worry very much when people doubt that. It's the reason I did the press conference I did 2 days ago. I care about the FBI's reputation. I care about the Justice Department. I care about the whole system deeply. And so I decided I'm going to do something no director's ever done before. I'm not going to tell the Attorney General or anybody else what I'm going to say, or even that I'm going to say it. They didn't know, nor did the media know, until I walked out what I was going to talk about. And then I offered extraordinary transparency, which I'm sure confused and bugged a lot of people. It's essential in this democracy that people see as much as they can so they can make their judgment. Again, they may conclude I'm an idiot, I should reason differently, but what I hope they will not conclude is that I am a dishonest person. I am here trying to do the right thing in the right way, and I lead 36,000 people who have that as their spine. That's what I want them to know. I don't care that people agree or disagree. That's what's wonderful about our democracy. But at its core, you need to know there are good people trying to do the right thing all day long, and you pay for them, and we'll never forget that.
I appreciate that. And within the context of these are human institutions, pretty clear to me as a non-lawyer that you had a bright line in terms of your decision about pursuing prosecution. But you did spend an extended period of time talking about what I think I take from you as being fairly objective analysis of what was careless in terms of handling of it, either ascribed to the former Secretary of State or to the department. And you said, and I quote during your comments, while not the focus of our investigation, we also developed evidence that a security culture of the State Department in general, and in respect to the use of unclassified email systems in particular, was generally lacking in the kind of care for classified information found elsewhere in the government. That's accurate, isn't it?
Yes, sir.
So struggling with this, and this is in the context of this hearing, Oversight and State Department, in this committee, as to how do we go from here and be clearer about how the State Department, we'll talk about this with the IG, and some of the comments that former Secretary Powell has made, including that the absurdity of the retroactive classification, and that now we have 1,000 of these emails from Secretary Clinton that's out in the public and are being spread even further. So there are other people involved. Sitting there, how does this committee go forward to make sure that the State Department can still function in the way it does with human beings and have conversations that are both transparent but also national security? What are the things we need to do to make sure that this doesn't happen again?
Well, I think a good start, I think the reason the chairman has the IG from the State Department here is to start that conversation. The IG knows deeply the culture of a department and is far better equipped than I to say you ought to focus here, you ought to focus there to make it better. So I think that's the place to start.
Thank you, Mr. Director.
Thank you,
I yield back.
Thank you. We'll now recognize the gentleman from Tennessee, Mr. Desjardins, for 5 minutes.
Director Comey, thank you for appearing so quickly on short notice. I think it's really important that you're here because of the way you laid out the case on Tuesday. There is a perception that you felt one way and then came to another conclusion. I, like many of my colleagues, put a post up back in my district and let them know you were coming, and in less than 24 hours I had 750 questions sent to ask you. So again, thank you for being here. But a common theme, just to summarize a lot of those concerns, were that in this case Clinton was above the law, that there was a double standard, and a lot of that was based on the way you presented your findings. Now your team, you said you did not personally interview her on Saturday, but your team did for about 3.5 hours, correct?
Yes.
Okay, do you know, in reading the review or the summary, did they ask Hillary Clinton about her comment that she had never sent or received classified information over private email?
I think so, but I can't remember specifically.
Okay.
It's a very long 302.
Okay.
I'd have to check.
And we'll get access to that. Do you know if they asked her when she said that there was nothing marked classified on my email sent or received?
Same answer. I'm not sure.
And so the same answer then when she said, I did not email any classified material to anyone on my email, there is no classified material. You don't know whether they asked her that?
I don't know whether they asked her that question. The entire interview was focused on. So what did you know? What did you see? What is this document? That kind of thing.
Do you know if they asked her whether she stands by the fact that she said she just used one device and that was for her convenience?
I don't know. I know they established from talking to her she used many devices during her 4 years. So I don't know whether they asked her specifically about that statement.
Okay, I guess
that's easy to check, though.
I guess my point is you're trying to get inside the head of Hillary Clinton in this investigation and know whether there was intent. And so we all know what she told the people. That's been well documented. She said that she did not do those things, that she did not send or receive classified emails, that she used one server and one device for her convenience. And since then, I think even in your statement, you recognize that those were not correct. Is that fair?
I really don't want to get in the business of trying to parse and judge her public statements, and so I think I've tried to avoid doing that sitting here.
Why do you feel that's important?
Because what matters to me is what did she say to the FBI? That's obviously first and foremost for us.
Right,
Our
and
evaluation,
honest people don't need to lie, is that right?
Honest people don't need to lie? I hope not.
Okay. Well, in this case, for some reason, she felt the need to misrepresent what she had done with this server all throughout the investigation. You guys, after a year, brought her in on Saturday, and in 3.5 hours came out with the conclusion that she shouldn't be prosecuted because there was no intent. Is that right?
No.
Okay, so I don't want to put words in your mouth, but is it fair to say that your interpretation of Hillary Clinton's handling of top secret information, classified documents, was extremely careless?
Yes.
And is it fair to say that you said that you went on to define extremely careless, that Hillary Clinton's handling of top secret information was sloppy or represents sloppiness?
Yeah, that's another way of trying to express the same concept.
And then just a few minutes ago, you also stated that you now believe that Hillary Clinton is not nearly as sophisticated as people thought. Is that correct?
Yeah, I think that's fair, actually. No, not as people thought, but as people would assume about somebody with that background.
Okay, so
I'm sorry. I should be clear about this. Technically sophisticated. I'm not opining on other kinds of sophistication.
All right. In the last minute, Director, I want to talk a little bit about precedent, because I think my colleague Trey Gowdy made a great point that there still is really no precedence in terms of punishment for this type of behavior. Are you familiar with Brian Nishimura's case?
Yes.
Okay, he's a naval reservist, for those who don't know, and he was prosecuted. What is the difference between his case and Hillary Clinton's case in terms of extremely carelessness and gross negligence? Because we're dealing with statute 793 section F, where it does not require intent. Is that correct?
No, I'm sorry. 793F is the gross negligence standard. That's
right.
1917.
Right. And is that why Brian Nishimura was punished?
No, Nishimura was prosecuted under the misdemeanor statute 1924 on facts that are very different. If you want me to go through them, I'll go through them, but very different than...
Okay. I think that there's been a review of this case, and they're very similar, and that's why people feel that there's a double standard. And
what they're reading in the media is not a complete accounting of the facts in that case.
Well, would you agree then with Representative Gowdy that there still is really no precedence for punishing someone like Hillary Clinton, and she could really go in, potentially be elected president and do this again without fear of being punished?
I don't think I'm qualified to answer that question.
All right, my time's expired. Thank you for your time.
Thank the gentleman. Now recognize the gentlewoman from New Mexico, Ms. Lujan Grisham.
Thank you, Mr. Chairman. I've had the benefit of when you're last to, or nearly last, to really have both the benefit and then to question the kinds of statements and the dialogue back and forth. And where I am settled at this point in time is in a couple of places, but particularly, I don't think there's any member in this committee, or quite frankly, any member in Congress who doesn't both want and expect that the FBI and the Department of Justice to operate in a fair, unbiased, highly independent manner. Otherwise, you can't appropriately uphold or enforce federal law. And while this has been stated in a couple of different ways, I'm going to see if we can't, I want to get direct answers. So, Mr. Comey, is there any evidence, given that that's the standard that we all want, desire, and expect, to suggest that Hillary Clinton was not charged by the Department of Justice due to inappropriate political influence or due to her current or previous public positions?
Zero, and if there is such evidence, I'd love folks to show it to me.
And in that regard, was there a double standard?
No, in fact, I think my entire goal was to avoid a double standard, to avoid what sometimes prosecutors call celebrity hunting and doing something for a famous person that you would never do for an ordinary Joe or Jane.
Thank you. And I really appreciate that you're here today and explaining the process in great detail, frankly. And this committee works at getting specific detail about a variety of reviews, investigations, policies, concepts throughout federal government. And I think I can say that this committee often finds that we don't get very much clarity or specific responses to the majority of questions that we ask. So I really appreciate that. And that in explaining that, what led the FBI to conclude that Hillary Clinton should not be charged. Saying that, however, I'm still concerned, frankly, that the use of this hearing and some of the public statements made by elected officials accusing the Department of Justice of using a double standard without any evidence at all to support that statement, leaning on accusations of such, in fact jeopardizes the very thing that we want the most, which is an apolitical and independent Department of Justice. And we have every right to ask these tough questions. And to be clear that the process that you use for everyone, including elected officials, works, and that there's a responsibility not to substitute your own political preferences for the outcome of an independent and apolitical Department of Justice investigations on any level, whether it involves Hillary Clinton or anybody else. Do you agree with that general statement?
Yes.
For me, that's a really important ethical line that I believe should never be crossed. I worry that some of what we did today could be, frankly, interpreted as violating that very standard. And for that, I certainly want the American people and my constituents who are watching to understand that very important line, and to be sure that our responsibility is better served making sure that we do have, in fact, an independent body whose aim it is to bring about truth and justice and uphold the federal law. And sir, based on everything that you've said today, I don't see any reason to disagree with your statements, your assessments, or the explanation of that process. With the little time I do have left, I do want to say that given that some of the classified material that we've both debated and talked about today can be classified later or up-classified, or that other agencies have different determinations of what constitutes classified and not, I do think that's a process that warrants refining. And if something can come out of this hearing about making sure that we do something better in the future for everyone, not just just appointed or elected officials, that ought to be something that we do. I'm often confused by some of the things that are clearly told to us in a classified briefing that appear to be different or already out in the public in some way, and I'm not sure who's making those decisions. I honor my responsibility to the highest degree, but I think that's a process that could use some significant refining, and that's my only suggestion, sir. Thank you for being here today.
Thank you. Thank the gentlewoman. We'll now recognize the gentleman from Georgia, Mr. Carter, for 5 minutes.
Thank you, Mr. Chairman. And Director Comey, thank you for being here today. I appreciate it. I'm over here. I'm over here. And I'm gonna be real quick and try to be succinct. I want to clarify some things that you said. And look, I don't want to go over everything that everybody's been through today. I mean, we've had some great questions here that have asked you about, you said this, she said that. Representative Gowdy made a great case of, this is what she said under oath and publicly, and yet you dispute that and say, no, this is the case. But look, I've just got a couple of questions, okay? First of all, did I understand you correctly that this decision was made within 3.5 hours of an interview, and that was all?
No, we investigated for a year.
You investigated, but you interviewed her for 3.5 hours last week and then came to the conclusion.
Correct. We interviewed her on Saturday for 3.5 hours, the last step in a year-long investigation.
Okay. Now, as I understand it, Hillary Clinton has testified that the servers that she used were always safe and secure. Yet you refute that and say, no, that is not the case at all. Were they ever secure? Were the servers that she were using, were they ever secure?
Well, the challenge, security is not binary, it's just degrees of security. It was less secure than one at the State Department, or as I said, even one at a private commercial provider like a Gmail.
Well, let me ask you this. She's got staff and she's got people around her. Did they know she was doing this? Did they know that she was using these other devices? Did anybody ever bring it to her attention and say, hey, you're not supposed to be doing that?
I think a lot of people around the Secretary understood she was using a private, personal email setup.
Then why didn't they say something? Don't they have a responsibility as well?
That's an important question that goes to the culture of the State Department that's worth asking.
I mean, look, we all surround ourselves with good people and we depend on them to help us. I don't understand. Should they be held responsible for that, for not bringing that to someone's attention? If I see someone who's not following protocol, is it my responsibility to report them?
Yes. Yeah.
Well,
Especially when it comes to security matters, you have an obligation to report a security violation that you may witness, whether it's involving you or one of your coworkers. But this is about. So
what about Brian Pagliano? Did he ever know? Do you know if he knew that she was not following proper protocol here?
He helped set it up.
He helped set it up. So obviously he knew.
Yeah. Obviously he knew that.
Okay. Is anything going to be done to him? Any prosecution or any discipline?
I don't know about discipline, but there's not going to be prosecution of him.
Will the gentleman yield?
I yield.
My understanding, Director, is that you offered him immunity. Why did you offer him immunity, and what did you get for it?
Yeah, that I'm not sure what I can talk about in open setting about that.
Well, he's not going to be prosecuted, so.
Right, but I want to be careful. I'm doing this 24 hours after the investigation closed. I want to be thoughtful, because we're, as you know, big about the law, that I'm following the law about what I disclose about that. So I'll have to get back to you on that one. I don't want to answer that off the cuff.
Director Comey, I am not a lawyer. I'm not an investigator. I'm a pharmacist. But I'm a citizen, and citizens are upset. I watched with great interest earlier this week when you laid out your case. And I'm telling you, you laid it out, bam, 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 here's what she did wrong, 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 wrong. And then all of a sudden you used the word, however. And it was like you could hear a gasp throughout the country of people saying, oh, here we go again. Do you regret presenting it in a way like that?
No, I'm highly, I think I didn't use the word however. I try never to use that in speaking, but I did lay it out, I thought, in the way that made sense. and that I hoped was maximum transparency for people. And
But
I know
that's the point. I'm sorry, but that's the point. It didn't make sense. The way you were laying it out, it would have made sense. And the way that the questions have been asked here, and we've made all these points of where she was obviously told lies under oath, that it would have been, okay, we finally got one here.
Yeah, I think it made sense. I just hope folks go back maybe with a cup of tea and open their minds and read my statement again carefully. But again, if you disagree, that's okay. But
when we just look, I've only been here 18 months, and I'm going to tell you, this inside the beltway mentality, no wonder people don't trust us.
Well, I have no, I know who you're talking about. I have no kind of inside the beltway mentality.
But this is an example of what I'm talking about here. It just was, as a non-lawyer, as a non-investigator, it would appear to me you have got a hell of a case.
Yeah, and I'm telling you we don't, and I hope people will take the time to understand why.
Mr. Chairman, I yield back.
Thank the gentleman. I will now recognize the gentleman from Arizona, Mr. Gosarf. Oh, let's go ahead and go to the gentleman from South Carolina, Mr. Mulvaney first.
Thank the gentleman. Director Comey, earlier today you heard a long list of statements that Mrs. Clinton has made previously, both to the public and to Congress, that were not factually accurate. I think he went down the whole long list. When she met with you folks on Saturday last week, I take it she didn't say the same things at that interview?
I'm not equipped sitting here without the 302 in front of me to answer in that broad brush.
But it's your testimony.
But I have no basis. We do not have a basis for concluding she lied to the FBI.
Gotcha. Did anybody ask her on Saturday why she told y'all one thing and told us another?
I don't know as I sit here. I mean, I'll figure that out.
Would that have been of interest to you in helping to establish intent?
It could have been, sure.
More importantly, I think, did anybody ask her why she set up the email system as she did in the first place?
Yes.
And the answer was convenience?
Yeah, it was already there. It was a system her husband had, and so she just jumped onto it.
Were you aware that just earlier this week her assistant actually said it was for an entirely different reason? It was to keep emails from being accessible, and that it was for a concealment purpose? She was, Uma Abedin was asked in her deposition why it was set up, and it was said to keep her personal emails from being accessible. Question, to whom? To anybody? Were you aware of that testimony?
Generally, yes.
Okay, so here's sort of the summary I take from what we've done today, which is that over the course of the entire system, what she did, she intentionally set up a system. According to your testimony, your findings, she was careless regarding its technical security. I think you said that even a basic free account, a Gmail account, had better security than she had. And she did that according to her own staffer's sworn deposition for the purpose of preventing access to those emails. As a result of this, she exposed top secret information to potential hack by foreign actors. You've seen the emails, we have not. I think you said earlier that the emails could be of the sort that would put national security at risk, and I think we had testimony earlier that got you to acknowledge that it might even put our agents overseas at risk.
Yeah, I don't think I agree with that, but it's still important.
Okay, all right. She kept all of that secret until after she left the State Department. She lied about it, or at least made untrue statements about it, after it finally came to light. She thereafter ordered the destruction of evidence that was destroyed so thoroughly that you folks could not do an adequate recovery. Yet she receives no criminal penalty. So I guess this is my question to you. Are we to assume, as we sit here today, that if the next president of the United States does the exact same thing on the day he or she is sworn into office, sets up a private email service for the purpose of concealing information from the public or from anybody, that as a result of that, potentially exposes national security level information to our enemies, lies about it, and then destroys the evidence during an investigation, that there'll be no criminal charges, if you're the FBI director, against that person?
Yeah, that's not a question the FBI director should answer. I mean,
no, I'm asking you if she does the exact same thing as president as she's done today, your result will be the exact same as it was 48 hours ago. There'll be no criminal findings, right?
If the facts were exactly the same?
Right.
And the law was exactly the same?
Right.
Yeah, the result would be the same.
And I guess under the theory that if the law is to be equally applied to everybody, that if a White House staffer does the exact same thing for the exact same purpose and exposes the exact same risks, that there'll be no criminal action against that person. That could be, as you've mentioned, administrative penalties. There are no administrative penalties, as I understand it, by the way, against the president, correct?
I don't think so, but I'm not a
I don't think there are either. I don't think you can take away the president's top security clearance, and I'm pretty sure you can't fire the president because we've tried. Not only would a staffer not have any criminal charges brought against them, but I suppose a summer intern could do the exact same thing under the theory that we're going to apply the law equally regardless of who the people are. My question to you is this, and it's not a legal question. I guess it's a common sense, ordinary question that folks are asking me. From a national security standpoint, somebody who used to lecture on that, does that bother you?
The mishandling of classified information bothers me no matter what circumstance it occurs in, because it has national security implications.
Does it bother you that the precedent that you are setting today may well lead to a circumstance where our top secret information continues to be exposed to our potential enemies?
No, in this sense. The precedent that I'm setting today is my absolute best effort to treat people fairly without regard to who they are. If that continues to be the record of the FBI and the Justice Department, that's what it should be. The rest of the implications in your question are beyond that. They're important, but they're not for the FBI to answer. We should aspire to be apolitical, facts and the law, treat Joe the same as Sally, as Secretary so-and-so. That's my goal.
If you would come to a different decision, by the way, I tend to agree everything you just said. If you would come to a different decision, do you think that would have a different precedential value that would keep our information more safe?
If we decided to recommend criminal charges here? I don't know. That's a good question. I don't know. I could argue it both ways. I guess I'm a lawyer. I can argue everything both ways, but I could argue that both ways.
Thank you, Director Comey. Thank you, Mr. Chairman.
Thank the gentleman. Now recognize the gentleman from Arizona, Mr. Gosar, for 5 minutes.
Thanks, Mr. Chairman. Thank you, Mr. Comey, for being here. My colleague alluded to Brian Pagliano, the IT advisor, and were you made aware of the deal of immunity with him?
I am aware.
Now that Attorney General Lynch has stated that there will be no charges, there's many that suspect that that he failed to answer questions in his congressional deposition, that he had something to hide. Why did your investigators at the DOJ decide it was necessary to offer Mr. Pagliano immunity?
As I said in response to the earlier question, I need to be more thoughtful about what I say about an immunity deal in public. It may be totally fine. I just don't want to screw up because we're doing this so quickly.
Okay.
In general, I can answer, because I've done it many times as a prosecutor. You make a grant of immunity in order to get information that you don't think you could get otherwise.
But you know that there may be something there in hindsight, right? You're looking ahead because of the pertinent information this person possesses.
Right. You believe they have relevant information to the investigation.
So did the investigators draft an interview report known as a 302 with Mr. Pagliano?
Yes.
Given the importance of this case, will you commit to voluntarily disclosing the 302s for review of Brian Pagliano and other witnesses interviewed as part of your investigation?
I'll commit to giving you everything I can possibly give you under the law and to doing it as quickly as possible. That said, then that means I got to go back and sort it out. For example, the 302 of Secretary Clinton is classified at the TSSCI level, so we got to sort through all that, but we'll do it. We'll do it quickly.
Yeah, I know you've done this because you've done this for Lois Lerner and other cases, so we would expect that. Now, Director Comey, Hillary Clinton testified before Congress and told the American people multiple times that she never emailed any classified information to anyone on her private email servers. Your investigation revealed 110 of Clinton's emails and 52 email chains contain classified information. Clinton told the American people, and I quote, "The laws and regulations in effect when I was Secretary of State allowed me to use my email for work. This is undisputed," end of quote. Your investigation revealed that that also wasn't true. Clinton claims she turned over all her work-related emails. Your investigation revealed that this wasn't also true. Clinton claimed that there was no security breaches and her private servers had numerous safeguards. Your investigation revealed 8 email chains on Clinton's private servers containing top-secret information, and that it was possible hostile actors gained access to sensitive information. Further, multiple people she emailed with regularity were hacked by hostile actors, and her private servers were less secure than a Gmail account, making a security breach all the more likely. Director Comey, it's a federal crime, as you know, to mishandle classified information in a grossly negligent way, and you stated Clinton and her colleagues were extremely careless. Clinton has publicly stated she was well aware of the classification requirements, yet she broke the law anyway. Multiple people have been prosecuted for less, and there is a growing trend of abuses in senior-level employees. The only difference between her and others is her total resistance to acknowledge her irresponsible behavior that jeopardized our national security and the American people. I think you should have recommended Clinton be prosecuted under Section 793 or Section 1024 of Title 18. If not, who? If not now, when? Your recommendation deprived the American people of the opportunity for justice in this matter. There shouldn't be a double standards for the Clintons, and they shouldn't be above the law. With that, I'm going to yield the rest of my time to the gentleman from South Carolina, Mr. Gowdy.
Thank you, Dr. Gozar. Director Comey, I want to go back to the issue of intent for just a second. We can disagree on whether or not it's an element of the offense. Let's assume for the sake of argument that you're right and I'm wrong and that it is an element of the offense. Secretary Clinton said that she was, quote, well aware of classification requirements. Those are her words, not mine and not yours. So if she were, quote, well aware of classification requirements, how did that impact your analysis of her intent? Because I've heard you this morning describe her as being less than sophisticated. She disagrees with that.
Well, I was talking about technical sophistication. The question is, I would hope everybody who works in the government is aware of classification requirements. The question then is, if you mishandled classified information, when you did that thing, did you know you were doing something that was unlawful? That's the intent question.
All right. Well, you and I are going to have to get together some other time and discuss all the people we prosecuted who were unaware that they were breaking the law. There are lots of really dumb defendants out there who don't know that what they're doing is against the law. But let's go with what you say.
I disagree. You may have prosecuted a lot of those folks. I did not prosecute a lot of those folks.
I was a gutter prosecutor and you were a white-collar prosecutor. Trust me, there are lots of people who don't know you can't kill other people. Let me ask you this. On the issue of intent, you say it was convenience, okay? You're a really smart lawyer. If it were convenience, Director, she wouldn't have waited 2 years to return the documents and she wouldn't have deleted them 4 years after they were created. So you can't really believe that her intent was convenience when she never turned them over until Congress started asking for them, could you?
Yeah, my focus, and I hope I made this clear, my focus is on what was the thinking around the classified information. I mean, it's relevant why the system was set up and the thinking there, but she didn't, I don't understand her to be saying, well, I think I've said it already, but that's my focus.
So I know I'm out of time, but it just strikes me you are reading a specific intent element into a gross negligence statute, not even general intent.
Gentleman's
a
time.
Specific intent
Gentleman's time is
element.
expired.
Yeah, I'm sorry.
Go, the director can answer.
I enjoy talking with him. The question you got to ask is, so why is it that the Department of Justice since 1917 has not used that gross negligence statute, but charging it once in an espionage case? And whether their decision was smart or not, that is the record of fairness. And so you have to decide, do I treat this person against that record? And if I do, is that a fair thing to do? Even if you're not worried about the constitutionality of it. And my judgment is no reasonable prosecutor would do that. That would be celebrity hunting. That would be treating this person differently than John Doe.
Director, I want to follow up on that. Why did you do what you did? You know, my interpretation of what the FBI is supposed to be doing is come to a determination of the facts and then turn it over to a prosecutor. You were a prosecutor, but you're not a prosecutor now.
Right.
It is unprecedented that an FBI director gave the type of press conference that he did and took a position that an unreasonable prosecutor would only take this case forward. Why did you do that?
Yeah. It's a great question. Everything I did would have been done privately in the normal course. We have great conversations between the FBI and prosecutors. We make recommendations. We argue back and forth. What I decided to do was offer transparency to the American people about the whys of that, what I was going to do, because I thought that was very, very important for their confidence in the system of justice. And within that, their confidence in the FBI. And I was very concerned, if I didn't show that transparency, that in that lack of transparency, people would say, geez, what's going on here? Something seems squirrely here. And so I said, I will do something unprecedented because I think this is an unprecedented situation. Now, the next director, who is criminally investigating one of the two candidates for president, may find him or herself bound by my precedent. Okay, so if that happens in the next 100 years, they'll have to deal with what I did, so I decided it was worth doing.
Mr. Cummings.
Director, I have just one question. I've been sitting here listening to this, and I really, this is something that bothered me in the Lois Lerner case, and it bothers me in this case. And I'm just wondering your opinion. Ms. Lawrence talked about this, the chilling effect of your having to come here and justify your decisions. And I know that you've been really nice, and you just explained why you did what you did, and I'm glad you're doing it. But, do you at all, and I mean, taking off, I'm just talking about, here you've got people making decisions and then being pulled here in the Congress to then say, okay, to be questioned about the decisions. At what point, or do you even think about it becoming a chilling effect? Because most people, when their decisions made, don't get this kind of opportunity, as you well know. There are no statements. They either get indicted or they're not. So I know that you see this as a special case, and I wonder whether you agree with Ms. Lawrence that we may be just going down a slippery slope. That's all I want to ask.
And my honest answer is I don't think so. When I talked to the chairman, I agreed to come because I think the American people care deeply about this. There's all kinds of folks watching this at home or being told, well, lots of other cases were prosecuted and she wasn't. I want them to know that's not true. And so I want to have this conversation, and I actually welcome the opportunity. Look, it's a pain. I've had to go to the bathroom for about an hour, but it is
Don't
really
worry,
important.
we're halfway done.
So. It is really important to do because this is an unprecedented situation. Transparency is the absolute best thing for me and for democracy. And I realize, Mr. Chairman, my folks told me I screwed up one fact that I should fix. I was misremembering. In the Petraeus case, we didn't find the notebooks in the attic. We found it in his desk. So I wanted to make sure I was fair to him about that. But I really don't think so. I don't think it has a chilling effect. Again, if there's another presidential candidate being investigated by the FBI, maybe they'll be bound by this. Lord willing, it's not going to happen again. Certainly, I have 2,619 days left in this job. It won't happen on my term, but if it does, I won't be chilled.
Thank you, John. If we need a humanitarian break, just give me the cue. But
no, I feel like we're almost done, though.
We're on the right trajectory. Okay. Yes, but we do need to. We'd like to recognize the gentleman from Alabama, Mr. Palmer, for 5 minutes.
Thank you, Mr. Chairman. Director Comey, your statement on Tuesday indicated that Secretary Clinton and her colleagues sent and received emails marked classified on an unsecured private email server that may or may not have been hacked by a foreign power. Are you aware that teenage hackers hacked the personal email accounts of CIA Director John Brennan, the Director of U.S. National Intelligence James Clapper, and FBI Deputy Director Mark Giuliano?
I am intensely aware. They didn't hack in the way we normally think of it, but that they, by trickery, got access to their accounts.
The point I want to make is that these were commercially protected personal email accounts that contained no classified information. Yet Mrs. Clinton used her personal email, not a commercial account, on a server in her basement without even this basic protection and transmitted classified information through that account. If teenagers in England were able to hack the personal email accounts of the Director of the CIA, the Director of U.S. National Intelligence, and the Deputy Director of FBI, does it concern you that sophisticated hackers or hackers working for foreign interests never attempted? I mean, does it seem reasonable that they never attempted or were never successful in hacking Mrs. Clinton's personal email accounts or one of her devices?
No, it concerns me a great deal, and that's why we spent so much time to see if we could see fingerprints of that.
Well, you said in your statement regarding your recommendation not to prosecute, to be clear, this is not to suggest that in similar circumstances a person who engaged in this activity would face no consequences. To the contrary, these individuals are often subject to security or administrative sanctions, but that is not what we're deciding here. Do you stand by that?
Yes.
Okay. I thought you would. You also said you could not prove intent. what I want to touch on a couple things here. One, a reasonable person would not have compromised classified information by keeping that information on inadequately secure private devices. In other words, such a person would be viewed as unreasonable and unsuitable for any position in our government that included any responsibility for handling and protecting classified information. Would you agree?
I would agree it would be negligent. I can't prejudge a suitability determination, but it would definitely be stared at very hard.
Well, let me tell you why I bring this up. I sat here next to Mr. Hurd, who served our country valiantly, put his life on the line. And I don't know if you could sense the passion and intensity of his questions, because he knows people whose lives are on the line right now. And in regard to his questions, if someone, a U.S. intelligence agent, had their mission compromised, or worse, had been killed or injured or captured because of the carelessness of someone responsible for protecting classified information, would intent matter at that point?
In deciding whether to prosecute the person, of course. But yeah, that's the answer. Of course it would. The matter would be deadly serious, but the legal standards would be the same.
Well, what we're dealing with in this hearing is not the lack of due diligence in handling routine government data or information, but the lack of due diligence by Secretary Clinton and her carelessness in handling classified information that could have compromised American national security and, as Mr. Hurd pointed out, the missions and personal safety of our intelligence agents. That troubles me greatly. And I think the issue here, and I do respect you. I have spoken in your defense many times, at this point to my detriment. But I do believe that your answers are honest and factual. But based on your answers regarding Mrs. Clinton's use of email, and based on what we know, it seems to me that she is stunningly incompetent in her understanding of the basic technology of email and stunningly incompetent in handling classified information. I mean, you should never associate the Secretary of State and classified information with the word careless. It doesn't matter. I mean, we have to exercise the utmost due diligence. All of us in this committee do in handling this. You do in prosecuting cases. And I see that in what you're trying to do. I just think we need to leave here with this understanding that there's more to this story than we know. If a foreign hacker got into this, I can assure you that they know what was in those emails that were deleted. They read them all. They know what is in the emails that we never received. Mr. Chairman, I yield back.
I thank the gentleman. We'll now go to the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.
Thank you. Thanks for coming on over to the Rayburn Building. As I understand it, your testimony today is that you have not brought criminal charges against Hillary Clinton, in part because you feel you can't prove guilt beyond a reasonable doubt, and in part because she didn't understand the laws with regard to emails and servers and that sort of thing. Question for you. When she erased these emails, or no, digress for a second. You, however, did say that if somebody did this under you, there would be consequences. If somebody did exactly what Mrs. Clinton did, but was one of your lieutenants, or you think one of the lieutenants under the CIA or some other agency that deals with top secret documents, what would you do to those underlings?
I would make sure that they were adjudicated through a security disciplinary proceeding to figure out what are all the circumstances and then what punishment discipline is appropriate. That could range from being terminated to being reprimanded, and then a whole spectrum in between: suspension, loss of clearance. It's a bunch of different options.
Okay, but tomorrow, let's say one of your top 2 or 3 lieutenants, you find out that they've had this separate server out there and they're keeping secret documents, you know, flipping them around. Do you think they should be fired? Not criminally charged, but fired?
Yeah, I don't think it's appropriate to say. I think it should go through. We have a very robust process. There ought to be a very intense suitability review of that person. Maybe there's something we're missing that would mitigate the punishment we would impose, but it would have to go through our system.
Okay, next question. Just for the listening audience here. At first, when I hear about erasing emails, I think it's like on my own phone where I might erase an auto insurance solicitation. The erasures here, however, were not just Mrs. Clinton pressing delete, there was a much greater effort made to make sure that these emails would never be recovered. Do you want to comment on what was done to erase the emails?
I think what you're referring to is after her lawyers say, although I'm not able to verify this, there were 60,000 or so left at the end of 2014. They went through them in a way I described in my statement 2 days ago, and then they produced the ones that were work-related, and then they erased from their system the ones that were not work-related. That was done using technical tools, basically, to remove them from the lawyers, from the servers, to wipe them away.
Okay, so in other words, the effort was not just Mrs. Clinton or somebody went delete, delete, delete. They went above and beyond that so that your top technical experts could not get back at these emails, correct?
Right, not fully. We were able to, by going...
You recovered a few.
Yeah, we could go through the lawyers' laptops and see some traces, but not fully recover them.
Okay, now, the information that I have, and you can correct me if I'm wrong, implies that these erasures were done in December of 2014, after the Benghazi scandal broke, after there were questions about the Clinton Foundation. Did you ever come across why she allowed these emails to sit out there, even for years after she stopped being Secretary of State, but all of a sudden, as these other scandals began to bubble up, she felt, or her lawyers felt, that she had to erase them?
Yeah, I think the way the process worked is she had emails that were just on her system. She actually had deleted some, I think, over time, as an ordinary user would. And then the State Department contacted her and other former secretaries and said, we have a gap in our records. We need you to look and see if you have emails and give them back. She then tasked her lawyers to engage in this review process of that 60-some thousand and make that cut, and then was asked by her lawyers at the end, do you want us to keep the personal emails? She said, I have no use for them anymore. It's then that they issued the direction that the technical people delete them.
Do you think Mrs. Clinton knew that the technical people were erasing these emails so that even your top technical experts could recover them?
Based on my sense now of her technical sophistication, I don't think so.
You don't think the lawyers told her that that's what they were doing, erasing all these emails that everybody on this committee wanted to look at?
Yeah, and I'm sure we've asked this.
What type of lawyer wouldn't tell their client they were doing that? But
I don't think they. I think our evidence from our investigations, they did not. That they asked her, do you want to keep them? And they said no, and they said wipe them away.
Okay. Now, as I understand it, the goal was just to erase personal emails, but you've recovered emails that wouldn't be considered personal emails at all.
Correct.
Okay. I don't know that you didn't recover them, but based upon the emails that you recovered, presumably her lawyers or somebody was going well beyond personal emails. Is it possible we'll never be able to recover emails that dealt with the Clinton Foundation or dealt with the Benghazi scandal? Is it possible because of what her lawyers did that they were erasing things that were incriminating, maybe involving items that you yourself were not particularly investigating, but that these have now been destroyed forever?
Yes, it's possible. As I said in my statement on Tuesday, we did not find evidence to indicate that they did the erasure to conceal things of any sort. But it's possible, as I said on Tuesday, that there are work-related emails that were in the batch that were deleted.
I'm sorry, when you go to this length to make sure you can never recover the emails who are erased, wouldn't you think the intent is to make sure nobody ever looks at them again? Why otherwise when you just go delete?
Thank the gentleman. We'll give the director time to, if he wants to respond.
Sure. I guess it's a bit circular. You delete because you want to delete. But what I mean is we didn't find any evidence of evil intent, an intent to obstruct justice there.
You wouldn't have been able to because you don't know it was deleted. But
okay. Thank the gentleman. Well, now recognize Mr. Russell of Oklahoma for 5 minutes.
Thank you, Mr. Chairman. Director Comey, thank you for your long service and your long suffering. I think we're toward the end of the line here. I want to state for the record, with regard to national security, I sleep a little easier at night knowing that you're at the helm of the FBI. And thank you for your dedicated service and your integrity.
Thank you.
You have stated in your statement and also multiple times here that there should be consequences for the mishandling of state secrets. If I held a top secret SCI in the Bureau, and I did hold one when I was in the United States Army in a career of service, I handle classified information here, but if I held that in the FBI and you discovered that I mishandled state secrets on a private server in my basement, would I be trusted by the Bureau to further handle top secret SCI information?
Maybe not. You would go immediately through a security process to review whether you should continue working for us, and if you do, what clearances you should retain.
If I violated the handling of state secrets in the FBI, would you consider me the best suitable candidate for promotion and higher responsibility?
It would be a serious concern, and we would stare at it very hard in a suitability review.
Although you have recommended to the Department of Justice that no criminal charges be brought to bear, are you recommending to the Department of Justice that there be no consequences for the mishandling of state secrets?
No, my recommendation was solely with respect to criminal charges.
What would you recommend?
I don't think it's for me to recommend.
But you do. You've been very open and even stated why you felt that these were unique sets of circumstances that called for greater transparency. You do make recommendations routinely, as you've stated here today. We're talking top secret SCI information that's been mishandled. You would take a dim view to that if I were an agent. What consequences? This is what the American people feel exasperated about. There seems to be no consequence. So in a case like this, if it's not going to be criminal charges recommended, what are the American people to do to hold their officials accountable if maybe they shouldn't be trusted for further promotion and higher responsibility?
And what I meant earlier is that's not a question that the American people should put to the FBI director. I can answer about the things within my remit, but that I understand the question, but it's not one for me to answer in my role.
Well, I hope it's one that the American people answer in the future, because we do have a choice about those that would mishandle information. And while we're all fallible human beings and we all make mistakes, in a case like this, I mean, for decades of my service in the Army Infantry and handling top secret SCI information, and then as a member of Congress, I mean, we know those responsibilities. Is it your view and others that have interviewed Mrs. Clinton that she would not have known what those responsibilities were?
No, I think in a way you would expect she understood the importance of protecting classified information.
Well, I would agree with that, and there's been a breach, and I think that the American people demand a consequence, that they demand an accountability. And I think it's important to uphold the form of our Republican government that we have a consequence. And with that, thank you for your appearance here today, and I would like to yield the remainder of my time to Chairman Chaffetz.
Thank you. I think if you yield back, through mutual agreement, Mr. Cummings and I have agreed that I do have about a dozen or so quick follow-up questions. You've been most generous with your time, but I would like to get through these last bit. Okay. And again, we'll do so with equal time. How did the Department of Justice, or how did the FBI view the incident in which Hillary Clinton instructed Jake Sullivan to take the markings off of a document that was to be sent to her?
Yeah, we looked at that pretty closely. There was some problem with their secure fax machine, and there's an email in which she says, in substance, take the headers off of it and send it as a non-paper. As we've dug into that more deeply, we've come to learn that at least there's one view of it that is reasonable, that a non-paper in State Department parlance means a document that contains things we could pass to another government. So essentially take out anything that's classified and send it to me. Now, it turned out that didn't happen because we actually found that the classified fax was then sent, but that's our best understanding of what that was about.
So this was a classified fax?
Correct.
So Hillary Clinton sends to Jake Sullivan, let me go back. Jake Sullivan says, they say they had issues sending secure fax. They're working on it. Hillary Clinton sends to Jake Sullivan, if they can't, turn into non-paper with no identifying heading and send non-secure. So you're telling me it's a classified piece of information. She's taking off the header and she's instructing them to send it in a non-secure format. Is that not intent?
Well, it actually caught my attention when I first saw it, and what she explained to us during our interview was, and other witnesses did as well, is what she meant by that is make it into a non-classified document. That's what a non-paper is in their world, and send it to us, because I don't need the classified stuff, I just need the...
Then why take off the heading? If it's going to be turned into a non-classified document, why take off the heading?
I assume because it would be non-classified anymore, so you wouldn't have a classified header on it. I think is what she said during our interview.
She wanted to be technically correct? Is that what you're saying? That you're...
No, I think what she said during the interview is, I was telling him in essence, send me an unclassified document. Take the header off, turn it into a non-paper, which is a term I never heard before, but I'm told by people I credit that in diplomatic circles that means something we can pass to another government.
You are very generous in your accepting of that. Let me ask you, Director, did any uncleared individuals receive any classified information over Hillary Clinton's server?
Did any uncleared people receive classified information? I don't think any of the correspondence on the classified emails were uncleared people. These were all people with clearances working, doing State Department business on the unclassed system.
Did Mr. Pagliano have the requisite security clearance?
As I sit here today, I can't remember. He was not a participant on the classified email exchanges, though.
But he was running the server. He set it up.
That's a different question. I'm sorry, I misunderstood your question then. Yeah, there's no doubt that uncleared people had access to the server, because even after Pagliano, there were others who maintained the server who were private sector folks.
So there are hundreds of classified documents on these servers. How many people without a security clearance had access to that server?
I don't know the exact number as I sit here. It's probably more than 2, less than 10.
And I appreciate your willingness to follow up with this. Did Secretary Clinton's attorneys have the security clearances needed?
They did not.
Does that concern you?
Oh, yeah, sure.
Is there any consequence to an attorney rifling through Hillary Clinton's emails without a security clearance?
Well, not necessarily criminal consequences, but there's a great deal of concern about an uncleared person not subject to the requirements we talked about in the read-in documents potentially having access. That's why it's very, very important for us to recover everything we can back from attorneys.
So what's the consequence? I mean, here, Hillary Clinton gave direction to her attorneys without a security clearance to go through documents that were classified.
Yeah, I think that's what happened in fact. Whether that was the direction is a question I can't answer sitting here.
So you're parsing that one a little bit for me.
No, you were just asking me. I don't
What's
know.
the consequence? They don't work for the government. We can't fire them.
Right.
So is there no criminal prosecution of those attorneys? Should they lose their bar license? What's the consequence to that?
Well, if they acted with criminal intent or acted with some malintent.
What you're telling us is it doesn't matter if you have a security clearance or not. Because I may be innocent enough. Hey, I'm just an attorney. I like the secretary. I'm trying to help Hillary Clinton. I'm not trying to give it to the Chinese or the Russians. I'm just trying to help her. So there's no intent? It doesn't matter if these people have security clearances?
Of course it matters. That's why I said that.
But there's no consequence, Director. There's no consequence.
Well, I don't know what consequence you'd have in mind.
Prosecute them.
An attorney for receiving from his client information that ends up being classified?
I asked you at the very beginning, does there a reasonable expectation that Hillary Clinton would send and receive, if not daily, hourly, if not daily, classified information? That's reasonable to think that the Secretary of State would get classified information at every moment. She's not the head of Fish and Wildlife. So the idea that she would turn over her emails, her system, her server to what it sounds like up to 10 people without security clearances, and there's no consequence. So why not do it again?
That's a question I don't think you should put to me. You're asking, I'm talking about my criminal investigation.
But how can that, there's no intent there? Does she not understand that these people don't have security clearances?
Surely she understands at least some of them don't have security clearances.
So if she understands they don't have security clearances, and it's reasonable to think she's going to be in classified information, is that not intent to provide a non-cleared person access to classified information?
You're mixing it up, though. I don't think it's reasonable to assume, mixing me up, sorry, it's not your fault, that someone who is maintaining your server is reading your emails. In fact, I don't think that's the case here. There's a separate thing, which is when she's engaging counsel to comply with the State Department's request, are her lawyers then exposed to information that may be on there that's classified? So,
and did they see any classified information? Did Hillary Clinton's attorneys, without security clearances, see classified information?
I sit here, I don't know the answer to that.
It has to be yes, Director. You came across 110, and they said they went through all of them.
Well, they didn't read them all. They just looked at headers.
So their excuse is, we saw the emails, but we didn't read them?
No, I think I said this in my statement on Tuesday. They sorted the emails by using headers and search terms to try and find work-related emails. We read them all.
I know that you read them all. Do you think it's reasonable or unreasonable to think that her attorneys, under her direction, did or did not read those emails? Because there were, let me go back to this, yes or no. Were there or were there not classified emails that that Hillary Clinton's attorneys read?
I don't know whether they read them at the time.
Did Hillary Clinton give non-cleared people access to classified information?
Yes.
What do you think her intent was?
I think then was to get good legal representation and to make the production to the State Department. I think it'd be a very tall order in that circumstance. I don't see the evidence there to make a case that she was acting with criminal intent in her engagement with her lawyers.
And I guess I read in criminal intent as the idea that you allow somebody without a security clearance access to classified information. Everybody knows that, Director. Everybody knows that. I've gone way past my time. Let me recognize Mr. Cummings for an equal amount of time.
Director, thank you for your patience. I want to clear up some things. I want to make sure I understand exactly what you testified to on the issue of whether Secretary Clinton sent or received emails that were marked as classified. On Tuesday, you stated, and I quote, only a very small number of the emails containing classified information bore markings, and I emphasize, bore markings indicating the presence of classified information, end of quote. Republicans have pounced on this statement as evidence that Secretary Clinton lied. But today, we learned some significant new facts, and I hope the press listens to this. First, you clarified that you were talking about only 3 emails out of 30,000 your office reviewed. Is that right?
3, yes.
3 out of 30,000, is that right?
Yes, at least 30,000.
At least 30,000. Second, you confirmed that these 3 emails were not properly marked as classified at the time based on federal guidelines and manuals. They did not have a classification header. They did not list the original classifier. the agency, office of origin, reason for classification, or date for declassification. Instead, these emails included only a single, quote, C, parenthesis, in parenthesis, and then end of quotation mark, for confidential on one paragraph lower down in the text. Is that right?
Correct.
Third, you testified that based on these facts, it would have been a, quote, reasonable inference for Secretary Clinton to, quote, immediately, end of quote, conclude that these emails were not, in fact, classified. So that was also critical new information. But there's one more critical fact, that these emails were not, in fact, and that is this, Director, and to the press, these emails were not, in fact, classified. The State Department explained to us yesterday, they reported that these emails are not classified and that including the little c on these emails was a result of a human error. The bottom line is that those little c's should not have been on those documents because they were not, in fact, classified. When Representative Watson Coleman asked you a few minutes ago about this, you testified that you had not been informed, and I understand that. I'm not beating up on you, I promise you. But can you tell us why, Director Comey? Because I want, because the Republicans are pouncing saying that the Secretary lied, and so I want to make sure we're clear on this. Can you tell us why, Director Comey, did you consult, and we're just curious, did you consult with the State Department about these 3 emails out of the more than 30,000? Or did this just not come up? What happened there?
Yeah, I'm not remembering for sure while I'm here. I'm highly confident we consulted with them and got their view on it. I don't know about what happened yesterday. It may be that their view has changed or they found things out that we didn't know. But I'm highly confident we consulted with them about it.
So this is totally different than what we understood yesterday. Today we learned that these emails were not in fact classified. They should not have been included, they should have not included those stray markings. They were not properly marked as classified, and the Director of the FBI believes it was reasonable for Secretary Clinton to assume that these documents were not classified. Chairman, you raised a question about whether Secretary Clinton's attorneys had security clearances. It is my understanding that they did. We can double check that, but that is my understanding. And we'll double check that. Going on, let me move to the next topic. You explained on Tuesday that you were providing, quote, an update on FBI's investigation of Secretary Clinton's use of a personal email system during her time as Secretary of State. You explained that you received a referral on this matter from the Inspector General of Intelligence Community on July 6, 2016. Is that right?
Yes.
Today, tens of thousands of Secretary Clinton's emails are publicly available on the State Department's website. And our staff have been reviewing the emails that were retroactively determined to include classified information. Based on this review, it appears that these emails included more than 1,000 individuals who sent or received the information that is now redacted as classified. Let me make that clear. About 1,000 people sent or received the same information that was contained in Secretary Clinton's emails and retroactively classified. Were you aware of that?
No, the number doesn't surprise me, though.
Why not?
Because they were doing the business of the State Department on this email system, so I don't know how many thousands of people work at the State Department, but it doesn't surprise me there'd be lots of people on these chains.
But you agree that we need to, that something needs to be done with regard to this classification stuff, because things are classified, then they're not classified, then they are retroactively classified. And I mean, does that go into your consideration when looking at a case like this?
Yeah, I don't pay much attention to the up-classified stuff because we're focused on intent. So if someone classifies it later, it's impossible that you formed intent around that because it wasn't classified at the time. I know that's a process. I wasn't familiar with it before this investigation, but I don't spend a lot of time focused on it in the course of a criminal investigation.
I understand. We also reviewed who these people are, and they include a host of very experienced career diplomats with many years of experience. So let me ask you this. When you received this referral from the Inspector General about Secretary Clinton's emails, did you also receive any referrals for any of the other 1,000 people who sent and received those emails? Did you?
No.
I understand.
Well, I should stop there. Within the scope of our investigation was a group of people closer to the Secretary. We looked at their conduct. Probably, I forget what the number is, 4 or 5 of them. But then the hundreds of others who may have been on the chains were not the subjects of the investigation.
I think I have 30 more seconds. I understand that the Secretary Clinton is the only one running for president, but it does not make sense that she was singled out for a referral to the FBI. Do you agree with that?
I don't think I agree with that.
Okay, so now let's go back to Colin Powell. Do you think you ought to look at his situation? Or Condoleezza Rice?
Well, there's been no referral on them. I know only sort of a superficial level their circumstances. This case strikes me as very different from those and not an inappropriate referral from the Inspector General.
Very well.
I thank the gentleman. Who was Hillary Clinton emailing that was hacked?
Yeah, I don't want to say in an open forum. We can get you that information, but I don't want to, again, I don't want to give any hostile adversaries insight into what we figured out.
Fair enough.
So I know the names.
Understood.
Yeah.
Was there any evidence of Hillary Clinton attempting to avoid compliance with the Freedom of Information Act?
That was not the subject of our criminal investigation, so I can't answer that sitting here.
It's a violation of law, is it not?
Yes, my understanding is there are civil statutes that apply to that. I don't know of a...
So let's put the boundaries on this a little bit. What you didn't look at. You didn't look at whether or not there was an intention or the reality of noncompliance with the Freedom of Information Act.
Correct.
You did not look at testimony that Hillary Clinton gave in the United States Congress, both the House and the Senate.
To see whether it was perjurious in some respect?
Yes.
No, we did not.
Did you review and look at those transcripts as to the intent of your recommendation?
I'm sure my folks did. I did not.
So, okay, and this is an important point, because I think those of us in Congress, knowing that you got a criminal referral from an Inspector General, thought that you were also looking at whether or not Hillary Clinton had provided false testimony, which is a crime, to the Congress. But you didn't look at that.
Correct. As I said, I'm confident my folks looked at the substance of the statements, trying to understand the circumstances around the entire situation.
Can you confirm that? I just want to
we'll confirm that. But and also, again, maybe I'm missing this, but I don't think we got a referral from congressional committees, a perjury referral.
No, it was the Inspector General that initiated this. Yeah. Did the fact that Hillary Clinton refused to be interviewed by the Inspector General, what did that say to you about intent?
Not, at least for our criminal investigation, not particularly germane.
Are you familiar? There's a website. I mean, lots of government agencies have websites. The State Department has a website, state.gov, and they have a YouTube site. Videos that are uploaded to a YouTube site, would those be considered federal records?
I don't know.
So they're paid for by federal dollars. They're maintained by federal employees. Would that not be a federal record?
Yeah, I just don't know. I'm sure there's an expert who could answer that in 2 seconds, but I'm not that expert.
Okay, we've kept you here a long time. I want to follow up on that. Is the FBI still investigating Hillary Clinton's aides?
No is the answer. The Department of Justice declined on all of those who were subjects communicating with her through that email system.
What recommendations did you make about her aides?
Same. We didn't recommend that anybody be prosecuted on those facts.
And if you could help us understand who precisely had been ruled out for prosecution, that would be...
Sure.
Did you look at the Clinton Foundation?
I'm not going to comment on the existence or non-existence of any other investigations.
Was the Clinton Foundation tied into this investigation?
Yeah, I'm not going to answer that.
The server that was set up in her home was originally set up by, you said, former President Bill Clinton.
Correct.
Do you know who paid for that?
I don't, sitting here.
Okay. I'll allow some equal time now for my colleague and friend, Mr. Cummings.
I'm going to yield 2 minutes to my 3.43 to Mr. Lynch.
Thank you, Mr. Director. We're talking about hacking, and so on this committee, we're very much interested in cybersecurity, and we review a lot of the major hacks that are going on. So just recently, and I would say in the last 18 months, we've had a major hack, February of 2016 at the Department of Homeland Security and the FBI. We had a hacking group. The Site Intelligence Group reported that a group called Crackers with Attitude had hacked 9,000 employees' data from the Department of Homeland Security, including names, email addresses, locations, telephone numbers. Also, 20,000 FBI workers. We had another hack, direct evidence, obviously, of those. Another hack at OPM of 4.2 million current and former federal government employees. Their information had been stolen, including Social Security numbers, which were not redacted. We had IRS in May 2015, 200,000 attempted and 100,000 were successful. We had State Department announced a breach of its computer systems after an infiltration forced the agency to temporarily shut down its classification system. We had the United States Postal Service, 800,000 postal employees, 2.9 million customers. The White House, Washington Post reported this is back in 2014, that the White House computer was hacked. National Oceanic Atmospheric Administration. I'm on another committee for financial services. We had Verizon, UCLA Health Systems, thousands and thousands and thousands of employees. Anthem Healthcare, Sony Pictures, Staples, Home Depot, JP Morgan. It gets into the millions. Community Health Systems, Target, TJX. So all these we have direct evidence, millions and millions and millions of people, their accounts being hacked. Any direct evidence that Hillary Clinton's emails were hacked?
No.
Okay. I have no further questions. I yield back.
Mr. Director, we are about at the end. I'm going to do a concluding statement, and then I think the chairman will. I want to, first of all, I want to go back to something that Ms. Watson Coleman said a little earlier. As an African-American man in this country, 66 years old, moving to the twilight of my life, we cannot allow black men to continue to be slaughtered. This morning, I woke up to my wife literally crying, watching the tape of this guy, Anton Sterling, in Baton Rouge, and then she looked at the one for Philandro Castle near Minneapolis. And I hope you watch them. There's something wrong with this picture. And don't get me wrong, I am all for, I've supported police, I am a lawyer, and I know how important police are, and I know there's so many great folks. But, Mr. Director, if you do nothing else in your 2,000 plus days left, you have got to help us get a hold of this issue. It is so painful. I can't even begin to tell you. And so I've been fortunate in my life. I've been very fortunate that I have not been harmed by the police, but I've been stopped 50 million times. Now, with regard to this hearing, I want to thank you again. You know, as I listened to you, you said something that I will never forget. And for some reason, it gave me a chill. You said there are two things that are most important to me. Two things. You said my family and my reputation. My family and my reputation. And I don't know whether your family's watching this, but I hope that they are as proud of you as I am. Because you are the epitome of what a public servant is all about. Sacrificing over and over and over again, trying to do the right thing, sometimes coming under ridicule, but yet and still doing the right thing. And so I hope that they are proud of you. The second thing I hope is that no matter what has happened in this hearing, I hope that you know that your reputation is still intact. And so I conclude by summarizing that I think some of our key findings today. First, the director testified that his entire team of 15 to 20 FBI investigators and analysts unanimously agreed on the recommendation not to prosecute Secretary Clinton. Second, Director Comey made crystal clear that Republican claims and some of the talking heads' claims of bias are completely false. He testified that he would treat John Doe the same way he would treat Hillary Clinton, and that he was very forceful on that point. Third, on the claim that Secretary Clinton sent or received emails that were marked as classified, that claim has now been significantly undercut. Those documents were not classified, and those markings were not proper. Finally, Republicans have repeatedly cried foul about a double standard when it comes to Secretary Clinton's emails. But Director Comey testified that the real double standard would have been to prosecute her with this completely inadequate evidence. Again, Director, I thank you, but I thank somebody else. And having practiced law for many years and having dealt with the FBI on many cases, I want to thank the people who work with you. Because this is not just about you. This is not just about Secretary Clinton. When we are addressing you, there are a whole cadre of people who give their blood, their sweat, and their tears to protect us as Americans. And I just want to thank them, because sometimes I think they are forgotten, unseen, unnoticed, unappreciated, and unapplauded. But today I applaud them and I thank you. Thank you very much, and I yield back.
And I thank the gentleman, and I concur with the idea that every FBI agent I have ever met has just been above reproach, and they make us proud, and they work hard, they put their lives on the line, they serve overseas, they serve domestically. Can't thank them enough for what they do, and I hope that is part of the message that we carry back. I cannot thank you personally enough, you on a personal level, for your accessibility, your ability to get on the phone with me the same day that you make your announcement, and then in rapid fire when I said to you, what day is best? We're going to have to do this, so which day is best for you? And you said Thursday, and here we are and doing it. I can't thank you enough. I wish all of the government employees would have that attitude and approach, and I really do. And I can't thank you enough. I look forward to working with you and your staff as we move forward in getting this documentation, things that you can't share publicly, and others. It is the intention of the committee to, I had told Mr. Cummings here that we would come back after votes. Votes have been pushed back now a bit, so what I'd like to do is to go into recess for 5 minutes, and then we will start with our second panel. Committee stands in recess until 5 minutes now. Thank you again, Director Comey.
Good afternoon. We have been listening to this hearing live on Capitol Hill for the last 4 hours and 40 minutes. FBI Director James